A very good morning and welcome to the 28th meeting of the Criminal Justice Committee in 2025. We have apologies this morning from Katie Clark. So our first item of business today is an oral evidence session on an affirmative and a negative instrument. So these are the Early Release of Prisoners Scotland Regulations of 2025, Draft SSI, and the Prisons and Young Offenders Institutions Scotland Amendment Rules of 2025, and that's SSI number 277 of 2025. So we're joined this morning by the Cabinet Secretary for Justice and Home Affairs, and I also welcome to the meeting Ms Fiona Tom, Head of Parole, Release and Reintegration, Scottish Government, Ruth Swanson, Legal Directorate, Scottish Government, and Theresa Medhurst, Chief Executive at the Scottish Prison Service. So I refer members to papers 1 and 2. And I'd like to draw members' attention to the additional written submissions of evidence that were received from organisations including Victim Support Scotland and Families Outside, which are included in our papers. So I'm grateful to all organisations who responded. So I intend to allow up to 30 minutes for this evidence session, and can I invite the Cabinet Secretary to make some opening remarks on the SSIs. Cabinet Secretary.
Thank you, Convener, and good morning to committee. I very much welcome the opportunity to attend today's meeting to discuss Early Release of Prisoners Scotland Regulations 2025 and Prisons and Young Offenders Institutions Scotland Amendment Rules 2025. The continuing rise in the prison population and its complexity is putting significant pressure on our prisons, impacting the Scottish Prison Service and partners' ability to ensure prisons function effectively and safely and accommodating those who pose the greatest risk of harm. This morning, the prison population stands at 8,404, and on Tuesday, the 21st of October, the population reached 8,430, its highest level ever. The Government has taken forward a range of measures to reach a sustainable population, including changing the point of release for some short-term prisoners and increased investment to strengthen alternatives to custody. And I have also established the independent review of sentencing and penal policy to inform future action. However, given the recent rate of increase and the associated risks, further action must be taken. It is therefore my view that the legal test for emergency release has been met and is necessary and proportionate to ensure the prison service can maintain the security and good order of prisons and the health, safety and welfare of prisoners and prison staff. While this is not a decision that was taken lightly, the increasing number of prisoners in custody is now at a level where the Scottish Prison Services assess capacity tolerance has been breached on more than one occasion. A number of establishments are identified at red risk, and SPS are at risk of not being able to comply with statutory duties and legal obligations. Protecting victims and public safety remains my priority, and I absolutely recognise that the early release of prisoners is a cause for concern for victims. That is why, if approved, these regulations will have safeguards in place. Only short-term prisoners with under 4 years within 180 days of release are eligible, and there are strict exemptions for those in prison for sexual or domestic abuse offences and those with non-harassment orders. There are also statutory exclusions. Details of this are included in the SSI and includes those in life sentences, registered sex offenders and those serving a sentence for domestic abuse. There is also a prison governor's veto if there is immediate risk of harm to identifiable individuals or groups. Should a prisoner pose an immediate risk of harm, they will not be released. The Prisons and Young Offender Institutions Scotland Amendment Rules 2025 has been laid alongside the EER regulations and seeks to amend the prison rules to allow governors to delegate the application of the governor veto to deputy governors. Deputy Governors are experienced in risk management and risk-based decision-making, and they also chair the risk management teams in their establishment. This change is intended to provide resilience in the application of the Governor's veto by allowing Governors in charge to delegate this to Deputy Governors where required, for example, when Governors are unavailable. The Deputy Government cannot delegate this further. Emergency release is not the answer to addressing the prison population issue in the longer term, but it is essential to provide some critical relief to those who live and work in our prisons. I am grateful for the cross-party engagement I have had on these important issues so far, and encourage committee members to support today's regulations and to work with me on our collective goal of a sustainable prison population. Thank you, Convener.
Thank you very much indeed, Cabinet Secretary. So I'll now open up to members to come in with questions. If I may just start with a couple of questions. The first one is just on some of the, I suppose, learning from previous emergency release. And the second question is on specific issue of OLR. So my first question relates to, and it picks up on a point that Victim Support Scotland made in their submission to committee. And one of the things that they've highlighted is or they're seeking clarity on, is whether prisoners released in previous schemes and who subsequently returned to custody will be considered for future emergency release schemes. I have to say it's not a point that I had thought about, but I think it's a valid point. I just wondered if the Cabinet Secretary might have any comment to make on that query.
So I'm certainly aware of the submission made by Victim Support Scotland and other organisations, Convener, and I know that committee will be aware, particularly in the context of learning lessons and developing release planning, for example, that the return to custody figures from the SDP 40 programme was 5% in comparison to 13% on the first early emergency release that we did last summer. And that, of course, is in the context of a reconviction rate of 43% within a year of release from custody. So those figures are encouraging and are going in the right direction. I think where the difficulty would lie, and I'll ask for some legal input to committee, if that's acceptable to you, Convener, is that in terms of when someone's sentenced, in terms of decision making around their management or release, while previous behaviour informs any risk management or release plan, in terms of the sentence that somebody is currently serving, that is the framework in which we are working within. Although there is also the Governor's veto, so there isn't a straightforward answer to that. But I think it would be difficult to penalise is perhaps the wrong word, but to take into account, you can take past behaviour into account in a risk assessment, but in terms of the question whether or not that changes someone's eligibility in terms of the law as it stands, it may well be not. But I'll ask Ruth if she wants to say a bit more about that.
I don't have anything further to add to what the Cabinet Secretary's already said. Under the regulations as drafted, we haven't drawn any specific exclusions for individuals who have been released previously under emergency release. However, as the Cabinet Secretary has stated, this is all subject to the Governor's veto as well, which will add a an additional safeguard to any decisions regarding an individual prisoner's release.
Okay, thank you for that. My second question, if I may, touches on OLR, which the committee has been in correspondence with the Cabinet Secretary on in the past, and indeed your letter of the 2nd of October indicates that you know that the individuals serving on order of lifelong restriction are excluded from early release scheme, as you've set out earlier. And we're aware that as of April this year, 277 people were serving OLRs, with 224 past the punishment part, but only 14 released. So given recent commentary from the Scottish Human Rights Commission and Lady Poole's recent judgment highlighting the importance of access to rehabilitation, I wonder if you could maybe just provide perhaps a response or some reassurance that all those currently on an OLR continue to present a risk to the public, or are assessed as continuing to present a risk to the public, and that there are no individuals being sort of held back, I suppose, just by virtue of the delays that we're experiencing across the prison estate at the moment.
So, Convener, our order of lifelong restrictions are a high tariff disposal. And we need to be clear about that, and it's a decision made by our independent courts in each of the individual circumstances. And the same with parole, just because you reach, or with life sentence prisoners, just because you reach the end of the punishment part of your sentence, that does not mean that you are guaranteed to be released. That is subject to risk assessment, and people have to demonstrate that they are ready for release. So, but there is a more general point, and actually this goes beyond OLR prisoners and is an issue for all prisoners, particularly those subject either to OLR and the parole system, that if our prisons are so congested, the work becomes very transactional. It's about locking and unlocking and getting people fed, getting people to the toilet, getting people to necessary appointments. And when the system is overpopulated, that reduces the capacity for relationship work, and of course it has an impact on the rehabilitative opportunities. So that is why I have made the point on a number of occasions that if we are making different decisions about some short-term prisoners and preventing people coming into prison either through good primary prevention work or alternatives to custody, you are therefore freeing up capacity for in-depth rehabilitation work that will be required in many circumstances where people pose the greatest risk, if they are ever to be able to return to the community.
Okay, thank you. Okay, I'm just conscious of the time, so I'll move on and I'll open up questions, and I'll bring Liam Curran first. Thank you.
Thank you. Convener, good morning, Cabinet Secretary. You talked in your opening remarks about the continuing rise and complexity of the population. That's acknowledged, but it was all entirely predictable and has been known about for years, as this place has been legislating, for example. The measures that you were talking about in your opening remarks to address this clearly aren't working to prevent the overcrowding. So, and in fact, VSS, Victim Support Scotland, in the submission we heard of earlier, say the schemes, the early release schemes, are not effective in reducing the prison population in the medium or longer term. So, Cabinet Secretary, how can the public be assured that, having endured early release previously, facing a further 1,000 prisoners being released between now and, I think, April, how can the public be assured we'll not simply find ourselves in this situation again post-April?
So the question for all of us as parliamentarians is that if we don't want to find ourselves constantly in the necessity of making decisions that provide short-term relief, we do have to step up the debate, step up to the challenge of being prepared to discuss and engage and work through the longer-term reforms that are needed. It is fair to say that Scotland has been an outlier along with the rest of the UK in terms of a very high prison population per capita in comparison to other jurisdictions for a very long time. I would dispute that it's all been predictable. I think there are some changes in more recent times. You touched on the complexity, and that has certainly seems to have increased post-COVID. The remand population is, higher than it was pre-COVID, for example. So there are, some changes that weren't predictable, and I also think the rate of the increase, while we've had many periods of a high prison population, but it's been quite stabilised at a high level, and at a level that I would be on the record as saying is too high. But the rate of increase that we've had recently, with the population shooting up by over 250 in short weeks, short months, we experienced that before at some point last year, and we are improving our understanding of the demand that is coming our way. There's been much work done in the Criminal Justice Board. People can gather lots of data, but it's data that supports the justice system as a whole that is required. And I will, reiterate the point that I made that emergency early release, I have never ever described it as anything other than providing short-term relief. And I've always been entirely candid about that. I've always been candid about the impact of any intervention that has been brought forward. So, and no intervention, and there's been several interventions, not all unanimously approved by people sitting around this table, but all because the problems, because there isn't just one contributory factor, there isn't just one issue or problem driving our prison population up. It does mean that there has to be more than one solution, and the government has always been frank every time we've come with, whether it's been HDC regulations, we'll be coming next month with regulations around foreign nationals, whether it's the regulations around GPS, whether it's the investment in community justice, whether it's the work that's been done to increase capacity within our prisons. None of that in isolation has been presented as getting any of us off the hook about the longer term and more radical reform that is needed.
So what, because that then begs a further question, that we're in this early release situation now for short-term relief. But since there have been previous early releases, it begs asking what other solutions for short-term relief were considered in this particular situation that perhaps were different from last time? So
there were other options considered, and before I advise committee of those, one of the issues or one of the factors that's different about this early release programme is it is longer, and it will operate for the full duration that we're allowed to operate it within the confines of the legislation. So the previous early release programme was for a shorter duration and released around 477 prisoners. Other options that were were considered. We had looked at the contemplation consideration that were given south of the border to yet again changing the point of automatic early release for short-term prisoners. And you'll remember that the advantage of doing that when we did SDP 40 is that it reduces the population from around 5% to what it would otherwise be. However, I discounted that option of another change to the point of automatic early release for some short-term prisoners in that it was too soon. We've just done SDP 40 and we've just changed the regulations for home detention curfew to align with SDP 40. So, and, you know, we have a commitment to evaluate SDP 40 and that was just too soon. The other option that was considered was to change the definition of what is a short-term prisoner and what is a long-term prisoner, and just discounted that. So there, in theory, you know, you could short-term prisoner is currently less than 4 years. You could, for example, in theory, change that to somebody serving less than 5 years, and I discounted that in part because the definition of short-term and long-term prisoners isn't always a helpful one. It's quite blunt. You know, there is a difference between people who are sentenced to less than a year, and we still are seeing several hundred sentences of less than a year, despite the presumption against short-term sentences. There's a difference between that and someone serving, say, 3 or 4 years, and then there's a difference between someone, serving, say, 46 years. So they're two examples of options that I considered but dismissed.
Thank you. Final question from me, just since you raised it. So yesterday in the Chamber asked about the long-term prisoners, and I wasn't entirely clear on the response. So if you permit me, I'll just put the question to you again. Cabinet Secretary, you've not ruled out the early release of long-term prisoners, although, for clarity, that's not being considered as part of this SSI, I understand. How likely is that to happen, the release of long-term prisoners, early release long-term prisoners? And given the greater danger that that would pose, logically, to the public and to victims, what enhanced victim notification are you considering in such a circumstance? And what analysis is the government doing of any enhanced, of any greater public risk of such a move?
No, I mean, it's very fair to raise that point, because I think I ran out of time in Chamber and actually really didn't address that point fully, or indeed if at all. If you recall, we did a consultation on long-term prisoners, which was, I'm trying to remember if it was last summer or the summer before, 2024. And that was because, we wanted to consider it, seek views from victim support organisations, but also those working in the field. And you'll be well aware that long-term prisoners are subject to the parole process. So there is a complexity to any change with the release arrangements for long-term prisoners. And as someone who used to work with long-term prisoners and write parole reports, I'm more than aware of the risk profile associated with long-term prisoners. And the question was, and this is a question where I have an open mind, that if the prison population was reduced further, there was less short-term prisoners, that enabled more rehabilitative work to be done with long-term prisoners. Is there a question then, and it's a question, is there a question about have we got the balance right for long-term prisoners who have determinate sentences, people who are returning to our community at some point? Is there a question about better progression, about better step-down facilities? Is there a question about the balance of how much of their sentence they spend in custody and how much they spend under strict licence conditions, perhaps even electronic monitoring, and under the threat of recall? And, you know, that there are concerns about prisoners who don't qualify parole and then they're released automatically, you know, 6 months before the end of their sentence, and they could have done several years. And does that serve the public well in terms of testing and actually managing people and preparing people for release who are eventually going to return to our community? Now, that's, you know, the arguments for at least having an open mind. What the consultation definitely said to us, because of the risk profile, is that you can't make any changes to how long-term prisoners are managed in the short. It's not something you would do as an emergency measure. You know, it needs to be consulted on, it needs to be planned. There would need to be additional investment in community justice social work, for example, who, because of the increase in the long-term population, that statutory population, that part of the population that require statutory social work input, you know, they are under considerable demands because of the nature of the statutory work they have to do for the parole board and so forth. So it's not an emergency measure. Now, what will the Sentencing Penal Commission come back with? Well, we'll all wait and see. So I merely say that, you know, I'm aware of the potential benefits, but also the risks and the investment that would need to be coupled with any change to how long-term prisoners are managed. So the short answer is I have an open mind. I know what I'm for. So I'm for, you know, community justice, home detention curfew, more expansive use of electronic monitoring for those on community disposals, you know, and indeed, you know, leaving prison. I'm very much in favour of, you know, making the best use of the estate, and we have increased the capacity of the estate. I want to replace, you know, old crumbling buildings. Want to ensure that HMP Highland and HMP Glasgow are delivered. What I'm not for, you know, beyond the prisons that we are committed to building and beyond modernising the estate, I'm not in favour of building our way out of this. Because if we build, they will come. We've already got a population of 8,400 and the challenge is to get a more sustainable population, because ultimately that's in the interest of public safety.
Thank you.
I'm conscious of time. We've got quite a number of members still looking to come in. I think we will, in the interest of robust questioning, I would propose that we slightly overrun this session, but I would ask for succinct responses. And with that, I'll bring in Jamie Hepburn, followed by Pauline McNeill.
Thank you, Convener. Just a few quick questions, if I may. You've spoken about the impact in terms of the current situation, in terms of, I think you described it as a transactional relationship between staff and those being held in our prison estate. But in the policy note, I was quite struck by this. It's a pretty stark thing to set out, as the current situation impacts on the prison service's ability to provide a safe environment for those living and working in Scottish prisons, and then goes on to talk about a decline in acceptable working conditions for staff within prison. So I suppose the question is, could you set out a bit more about the impact on staff safety in particular in terms of the current situation and how these regulations might alleviate any such concerns?
So we will alleviate the extremely difficult staff working conditions by reducing the population. I'm acutely aware of the challenges faced by our prison officers and other partners, social work, NHS, nursing staff that are working in our prisons as well. They need to be supported and enabled to do the job that they wish to do. And people join the prison service because, one, they're focused on public safety and protection of the public, but they're also invested in, where appropriate and possible, the rehabilitation of offenders. And we have to take very seriously staff working conditions and also staff safety as well as the safety of other prisoners. And I'm very aware of the work and the views of the Prison Officers Association, as well as also Prison Governors Association. I'm trying to be brief, Convener. Convener, would you want to hear anything from Ms Medhurst in terms of staff conditions?
Thank you very much. Thank you very much, Mr Hepburn. So what happens in prisons today and every day just now is that staff are being redeployed from jobs that they have been selected to do, mainly around about employability, rehabilitation, and moved into jobs and roles where we ensure that people are getting access to fresh air and exercise, that they are being provided with their meals, because the conditions within prisons are such. We have got so many people displaced, we don't have enough specialised cells for them. It puts increased pressure on just getting through the transactional work, as the Cabinet Secretary says. Because of that increased pressure as well, we do see increases in staff absence, and we have also seen increases in assaults on staff as well recently, which is particularly of concern. And a lot of that, not all of it, but a lot of it can be born out of frustrations, because people aren't getting time out of cell, they're not getting access to rehabilitation services and support, and they're also being taken away from their home establishments and moved to other places to try and even out the pressures across the estate. Those are the kinds of decisions that are being taken on a daily basis. That's the kind of conditions that our staff are working in just now, and that's why we need the pressure to be alleviated.
So staff safety quite central to thinking behind these regulations. Okay. Just another couple of very quick questions, if I may. You've been on the back of the Victim Support Scotland responses to both of the sets of regulations we're looking at here. The first relates to the victim notification scheme. There was some view expressed that subscription to that scheme is still quite low. It would just be useful to know what's being done to try and promote it and ensure that victims are aware of, and clearly can't be compelled to be on the scheme, but they're aware of their rights to be able to be part of it.
No, and that is a very, very fair comment as well. I would certainly like to see more people be proactively involved, included in the victim notification scheme, and we are working with partners to improve people's awareness of the victims notification scheme, but in acknowledgement of the relatively low take-up rate to be part of the victim notification scheme. You don't actually need to be registered with the victim notification scheme to get information about the perpetrator in your case. People can contact Scottish Prison Service directly, or they can receive the information via a victim support organisation. And obviously with the Victims, Witness and Justice Reform Bill and other work that is in train, there is, and particularly through the Victims Task Force, there is a body of work to improve victim notification scheme, which is another point. That work would need to be considered, and it's a germane issue, particularly in and around any developments of long-term prisoners, or even if there's no developments around the management of long-term prisoners. There's a body of work there that we're committed to improving the victim notification scheme. But in terms of early emergency release, there are other routes to get the information that you need.
One final, very straightforward question, if I may. It's from Victim Support Scotland there, response to the Prisoners and Young Offenders Institutions Amendment Rules order. And I think the answer will be yes, on the basis of what you said, Cabinet Secretary. But just to see if we can get in the record, they were seeking assurances that any deputy governor with delegated powers would have access to the same information that a governor would in terms of making.
Absolutely. It's deputy governors who are chairing their establishment's risk management committees. So absolutely, they would have the access to the same information from police, social work, other sources. Does Ms Medhurst wish to add anything?
No, that information is provided to them as well. So, and what we're doing this time, from lessons learned previously and from feedback from governors, is that we're centralising the process to pull that information together, take some of the pressure off, make it more streamlined, and then providing that information to governors and or their deputies.
Okay, thank you.
By Fulton McGregor.
Good morning. And Teresa Medhurst for sharing the insights into why we're facing this crisis in the Scottish Prison Service. And you've always been frank and open with the opposition parties, and I appreciate that. If you don't mind, I'd like to try and understand what all of this means in terms of short-term prisoners and all that. It's quite hard to follow, but in the Bail and Release Act that we passed, am I correct in saying that instead of that changes it to serving 40% of a sentence? Or where does that come in?
Right. So in terms of short-term prisoners, the legislation that changed the point of automatic early release for some short-term prisoners that's not the Bail and Release Act. That was the 2023 legislation. The short-term prisoners bill was earlier this year, and for some short-termers, not those convicted of serving sentences for domestic abuse or sexual offences, and there was some other exclusions as well. Like they did south of the border, we changed the automatic early release point for some from 50% of time served to 40%.
Thanks. Yeah. And further to that, there's been a change in at what point in the sentence you could be eligible for home detention curfew. It was 25% of your sentence, now 15% of your sentence.
So if you recall, we took through committee home detention curfew regulations because they were aligned with the previous arrangements for short-term prisoners. So we wanted to align them to the short-term prisoner 40 programme.
So before we get to the powers that you want to use today and ask the committee, there's already potential shortening of the time served in jail under these proposals for some prisoners.
Yes, yes.
Yep.
Although in terms of, I might ask Ruth to explain this, because I always make a wee bit of a dog's dinner of it. Although eligibility, for some kicks in, and there are exclusions around who's eligible for home detention curfew as well. In terms of the eligibility, kicking in at 15% because of the other requirements and the assessment process, people are further into their sentence. Do you want to explain a wee bit about that, Ruth, please?
Yes, so in terms of home detention curfew, there's no entitlement to being released in home detention curfew. An individual prisoner can be eligible from the 15% point of their sentence, but as the Cabinet Secretary has already highlighted, there are a number of exclusions to being eligible for release in home detention curfew. You also have to serve a minimum period, I think, of 3 months it is, and there's a range of statutory exclusions in terms of the offence. Yeah. It is also all subject to a risk assessment. These are individualised assessments of prisoners' eligibility for release in home detention curfew, which is different from automatic release, as you were discussing earlier, which is where certain short-term prisoners can be released, are automatically released after serving 40% of their sentence. They're quite different.
They're also, Ms McNeill, in terms of home detention curfew as well, has been risk assessed. Everybody's tagged. There are conditions of release and curfew
Yeah. No, it's helpful. It is quite important, I think, to get your head in where we are, because it is complex and I understand that. I find that helpful, thank you. Secondly, I did ask you about this in the Chamber yesterday. Now, I know there's more than one reason for the rise in the prison population. We had this discussion with Teresa Maters. But it does appear that the rise in longer sentences, if I understood what you said yesterday, and you're not the first person to say this, it seems that the courts are handing out longer sentences as well, for whatever reason. And I just wondered if you thought, is that the case, first of all? Do you agree it's maybe quite important for somebody, whether it's a committee or some other government department, to understand why that would be the case? Because you've said it couldn't have been predicted, but if there's going to be changes in the trend of sentencing and how long we hold prisoners for, maybe it's quite an important thing to understand.
Yes, and the answer to your question, Ms McNeill, is that people across the board, on average, are receiving longer term or longer sentences. The average increase is the sentences are up by 31%.
And does that indicate that's because, I mean, you might not be able to answer this, does that indicate that's because there are more serious crimes being committed? Or is it not possible to tell that? Or the courts are just taking a harder view on sentencing, which they're entitled to do when they're independent judiciary?
So I suppose it's in some degree difficult for me to speculate.
Yeah.
But there is certainly information, available from the Sentencing Council. There is a range of evidence that is available. It is all prison groups are on average serving longer. So it's a kind of across the board sentence inflation is how I would describe that. It is also the nature of offences. So, the prosecutors and the Crown are more successful in pursuing historical sexual offences. More people are coming forward, have the confidence to come forward around historical sexual offences. So, the profile of prisoners is changing in that, more long-termers, but also more sex offenders.
Yeah. Just lastly, I did hear, it was an interview, I think, of a defence lawyer who said that some of their clients that are serving time in prison that might be released are not actually ready for release and would maybe just rather be in prison to get some of the services, rehabilitation or whatever it is they think they need. I mean, has that happened? I don't know, maybe Teresa Maters could answer that. Do you come across this, that maybe some prisoners don't think they're ready to go out to community, and is there provision to consider that?
Certainly not within these regulations, and it probably doesn't apply quite so much to those serving short sentences. It more, I think it's more akin to those serving longer sentences when you consider, particularly for somebody who may have spent 10 years in a closed environment where everything is regulated and provided for them, and then they're then looking at release, they can become extremely anxious and concerned. And I think that's why the Cabinet Secretary alluded to earlier about having a discussion about, what is a long-term sentence, what should it look like in terms of the custodial environment, as well as the return to the community as well. But certainly we do come across individuals who do have concerns and who sometimes, unfortunately, deliberately set out to, take part in activities that will ensure that they are not liberated because they do have heightened concerns around what's waiting for them outside.
Thank you very much.
Dr McGregor.
Cabinet Secretary Teresa Maters and the rest of the panel. The question I've got is following up from Pauline McNeill's earlier line of question there, and it's about those changing demographics in prison. Pardon me, sorry. I've brought it up here before and in the Chamber, an older population with significant health and social care needs. And I know that some governors, most recently perhaps and publicly the Governor at Glen Oco, have actually expressed concerns about whether typical prisons are suitable and best place for these type of prisoners, and is there a more of a health care setting required? Well, obviously a health care setting within a justice and prison context, because obviously there's different risks. But what I wanted to ask Cabinet Secretary in relation to this legislation that's in front of us today is, has there been any further work on this aspect, or any consideration or assessment from the Government in conjunction with the Prison Service about how making changes in this area might impact the prison population beneficially and perhaps relieve some of the pressure that we're experiencing just now?
Mm-hmm. So, Convener, I'll try and be brief, because I think I might be at risk of repeating what I've said to Chamber and Committee previously. I mean, we are scoping out some work in terms of, you know, what would different models of care be for that older population. You know, the notion of a hospital stroke prison stroke secure care home would be a substantial capital investment. And so, but nonetheless, you know, we're looking at a range of options. They're not quick options, but in the meantime, in terms of the prison healthcare group that I chair and is attended by all health ministers, we are certainly trying to ensure better cross-government, cross-service work to support older people in custody, and in particular to support the task that the prison service have. It's also important to highlight that the new HMP Glasgow is built in a way, or will be built in a way that has smaller, more community-type units within this, you know, much larger establishment, and as part of the design has improved health facilities. But I'll ask Ms Medhurst if there's anything further she'd like to add.
Thank you, Cabinet Secretary. I think, certainly from my perspective, we are experts in criminogenic need, not social care need, and therefore I really welcome the cross-government support around what is an increasing and very, I suppose, problematic part of the population for us, in that we don't have expertise in that area. So we are relying on partners and others, but really welcome the exploration of different models of care and what that can look like, because that certainly would alleviate many of the pressures that staff are facing. And you know, if I'm being honest, within a custodial environment for those individuals that we are referring to, then, you know, high secure facilities are not required. There is something else that could better support and provide the care that they need, as well as focus on their criminogenic needs as well.
Thanks. That's really positive. Thank you.
Just a very final question, Cabinet Secretary. Obviously, emergency release, in particular this release process that we're discussing today, places significant additional pressures on local services. I think you alluded to that in your opening statement. So local authorities, health services, third sector. Now, they're familiar, obviously, with previous emergency release processes, but it was just to, I suppose, seek your reassurance that local services are being supported to manage the release, the next lot of releases, should this be passed today, and if they require additional resource or assistance will that be forthcoming?
So we're continuing to engage with partners around all of that. It is important to stress that the phasing of the tranches of release is very important in terms of managing that pressure on to the community. There wasn't any additional financial resource provided when we did early emergency release last summer. Nonetheless, there is weekly planning meetings because the planning is absolutely imperative both for our local partners but also for individual people that are being released. I've at the start of this particular journey, I've met with COSLA and others, and will continue to engage very, very closely.
Okay, thank you very much. Okay, thank you for that. So our next item of business is to consider a motion to approve the affirmative SSI on which we've just taken oral evidence. So can I invite the Cabinet Secretary to move motion number 6S6M 19222 in her name and make any brief additional comments she wishes to make.
Moved, Convener, and I refer to my opening statement.
Thank you very much. So do members have any points that they would like to make?
Yes.
Liam Kerr.
Thank you, Convener, and thank you, Cabinet Secretary, for the session this morning. I will oppose this SSI, and I believe that the committee should vote against it. My reasons for taking that position is I think it's clear that Victim Support Scotland are right when they say this is no solution. And we will be in this situation next April, following a further 1,000 prisoners having been released. I think the knee-jerk response has now become the default response, and there's been no real progress that I can see since the previous early releases to stop this repeatedly happening. I noted the Cabinet Secretary didn't expressly rule out long-term prisoner release, although I do recognise her comments. I think that was helpful, but it wasn't ruled out. And I think the argument that this knee-jerk release of short-term prisoners becoming the default response without ruling out long-term prisoners suggests that this could be the thin end of the wedge. I don't see enough evidence of other options being considered. I noted the remarks the other day where the SPS were saying that a new prison the size of HMP Grampian or Shotts is what's required to relieve the overcrowding, but the Cabinet Secretary suggested that there won't be any further new builds as, to use her own words, build it and they will come, which, with respect, I don't find to be a coherent argument, given that, for example, HMIPS suggests that early release doesn't address any of the root causes of the problems. It is not the building of prisons which raises or lowers the prison population. It is other issues within the justice system. I shall.
Member for taking intervention. Just to be clear, does the member recognise that this is an emergency situation? And is the member actually saying that we should be building our way out of this situation by building more prisons?
So I think there is clearly an emergency, but as I said in my remarks earlier, this was not unforeseeable. This has been entirely foreseeable over many, many years. And as I just said, there's simply no evidence that the government has been taking the steps that have been required to stop an emergency happening. And I'm certainly not saying that the solution is to build, is to just relentlessly build out of problems. What I just put forward is that the solution to a prison population is to look at the justice system holistically and look at how you address a prison population. That has not been done. The Cabinet Secretary's remark, build it and they will come, is simply not coherent because it is not the availability of prison space that impacts the size of the prison population. It is the wider context within which the justice system takes place. And just on that point, you see, yesterday I put to the Cabinet Secretary about the new building, about Glasgow and Highland. And the Cabinet Secretary said to me that the reason, another reason there would be no new building was because of the cost. Now, Glasgow and Highland are massively delayed and subject to massive cost overruns. And it surely cannot be correct to found upon the government's inability to deliver on infrastructure on time and on budget as a way to avoid dealing with overcrowding. So,
well, Mr. Kerr, give way. Am I allowed to intervene?
Yes, of course.
Okay, thanks. I am listening very carefully to Mr. Kerr, as always, and I think it is important that we do critique the past as well as debate the future. But could I ask Mr. Kerr that what does he propose that we do right now, as in right now? What is he proposing that we do instead of early emergency release, bearing in mind that relief, yes, time-limited relief is required right now? What is he suggesting we do? Is he seriously suggesting we do nothing and ignore the advice from the Scottish Prison Service, HMIPS, Prison Governors Association, POA? Yes, we all want longer-term action, but right now action is required. Are you seriously proposing we do nothing?
On the contrary, I think the problem here, with respect, Cabinet Secretary, is that the government has done nothing, because this is not a new situation. As I said to Rona Mackay,
what would you do?
This has been in train for so long that there have been previous early release programmes. So were I in government, I would have immediately accelerated. I wouldn't have allowed the cost overruns and the time overruns on HMP Glasgow and Inverness to go ahead. And, for example, one of the other things I understand...
Way again?
No, let me answer the question with respect, Cabinet Secretary, because HMP Kilmarnock was taken back into the public sector, and my understanding is that part of the offer that Serco made, and by all means, Cabinet Secretary, after I've said this, come in and correct me if I'm wrong, but I believe that part of Serco's offer was to open a new wing as part of HMP Kilmarnock, thus increasing capacity and thus potentially solving the capacity, the overcrowding issue. Now, the fact that HMP Kilmarnock was taken back into the public sector for perhaps some might suggest ideological reasons may have ruined that possibility. So I think, Cabinet Secretary, this is an ill thought through and I think a very risky response to a situation which we knew and have known for a long time would occur, and I won't be voting for it, and I don't think the committee should either.
Thank you, Convener. Well, I do support the regulations, and I think the committee should support them, and broadly speaking, it's because the circumstances that have been set out require us to act. It's interesting that the Deputy Convener conceded at the outset that we are in clearly an emergency situation. Well, when an emergency situation, it compels us to respond urgently. And frankly, I'm afraid to say the Deputy Convener's response to the Cabinet Secretary did not give any indication as to what would otherwise constitute an urgent and emergency response. It would be very easy to pass on by and abdicate any responsibility for trying to find a solution. And with respect, I would say that would be a knee-jerk response. And it's very clear that the regulations have been taken forward, not been taken forward lightly. People will be watching this. I think it's important that we remind ourselves that there are very clear restrictions in terms of the cohort of prisoner that will be eligible for. At least it's very clearly set out. Life prisoners will not be eligible. Untried prisoners will not be eligible. Terrorist prisoners will not be eligible. Those subject to proceedings under the Extradition Act will not be eligible. Those subject to notification requirements under the Sexual Offences Act will not be eligible. Those serving a sentence of imprisonment or detention for an offence that is aggravated, described in the Abusive Behaviour and Sexual Harm Act are not eligible. There are others I could go on. That's not to dismiss the reasons as to why those who are going to be eligible have been imprisoned. I recognise the courts have made that assessment and determination. I don't dismiss that lightly, but we must remind ourselves that there are prisoners who are not going to be eligible. And of course, we have the Governor's veto now to extend that to Deputy Governor's veto as well. They can make a further assessment, and those who might otherwise be eligible could be vetoed. I think the most compelling reason that I've heard thus far, we talked about the impact of the environment, the impact in terms of being able to undertake rehabilitation of prisoners, which I know is sometimes dismissed as being important. It is an essential part of the work undertaken in prisons as far as I'm concerned, because if it's done properly, it actually creates a safer society. But for no other reason than we have heard that this has an impact on the safety of those working in the prison environment, that says to me that we should be supporting these regulations today.
Thank you very much. So if no other members wish... Oh, beg your pardon, Polly McNeill.
I start by saying I don't find this easy at all. I do see that there's an emergency situation, and I did listen to Phil Fairley this morning and the trade unions. I think it must be a horrendous situation. So for that reason, it's got to be considered very carefully. However, I'm going to oppose the SSI. I want to set out my reason for that. And it's on the balance, I have to say. There are consequences. It isn't a straightforward issue. Whichever way you vote on this, you want to release the pressure in our prisons. But if we do so, it's the third time we've been here. And my main concern is that I just do not want to endorse an approach of managing prisoners in this way. It's already complex, and I appreciated that exchange with the Cabinet Secretary, trying to understand what sentencing policy is in Scottish prisons now. And I dearly wish that the committee were given the time to do its job here in the long run, because I do agree with this point about the longer term. And you know how I feel about this, convener, is I feel that the last 6 months of this Parliament, we as a committee should be able to examine some of these bigger issues. That's our job. You can see the Sentencing Council has its job, and I want to say something about that. But we have a job too, but we don't have the time to do it, and I won't go into the reasons why. I am not convinced the Sentencing Council are doing the job they were set up to do, but that's just my initial take on it. Because I do think there should be clearer answers to the change in the trend. You cannot take a period of 18 years or 20 years and say, well, we couldn't have predicted this. Of course you couldn't. But it's not going to stay the same, that's for sure. You know, you might have an older population. You don't know that the courts, because they are independent. So I appreciate all of that. But I do think that the Sentencing Council should be more up front and maybe have more of an exchange with us as the elected members about how they see they deal with this in the longer term. And I do agree with the Cabinet Secretary on that. I do have to be constantly reminded that we did actually change the approach to long-term prisoners, which is if they're not released on parole, then they're not eligible till 6 months before the end of the sentence. So, I mean, you can already see how complex sentencing has become for many reasons. So I think that's certainly a legacy discussion that the committee needs to have. And just lastly, the convener asked about lessons learned. I'm sure lessons have been learned. I'm sure they're learned every time we have to go through this. But the communication with victims, and I know that's not easy. I know we ran out of time. I did want to mention that Families Outside put an appeal into the committee to make sure that the importance of families, which I know Cabinet Secretary is fully aware of, make a huge difference to reoffending rates, and they've pleaded for better communication. So I think it's very difficult. I'm not going to pretend otherwise how difficult it is, a decision. But anyway, I thought I should contribute to the debate and explain my decision. Thank you.
Thank you. Andrew Mackay.
Very briefly, I mean, notwithstanding the arguments that we've heard, and I think we all agree on the bigger picture, the long-term picture, I just wanted to bring us back to the core reason this SSI has been brought, and that's because it's an emergency situation, and that's what this is about. And I can't understand why members of the committee would not understand that an emergency situation requires immediate action. And I will be supporting this SSI.
Thank you. And Sharon Dowie.
I would agree with the comments that a lot of the other members of the committee have put in as well, but the one thing that concerns me is we're talking about an emergency situation, and an emergency situation is something that we've not foreseen, whereas I've got a concern that this now feels as if it's business as usual. We're now here for the third time doing an emergency release of prisoners. Mr McGregor said earlier on about we know that we've got an ageing population in the prisons. Wendy Sinclair Gibbons done a report a few years ago highlighting that and asking what we were doing about the ageing population. That would take pressure off the prison service. And I don't see that we've made much action on it. And again, the people that are within prison are there for a reason. They've caused possibly mayhem in the communities, and I feel that as if, although I realise that we must protect prison officers, we're going to move this cohort of people from the prison back into the community, where they're now going to cause mayhem for our police officers who are already struggling to deal with the amount of cases that they have, and they feel as if there's no action. So I don't think it's an emergency situation. I feel as if it's now business as usual, and I would like to see more in diversion from prosecution. And I feel as if we will be back here again.
Okay, thank you very much. Okay, if no other members, I think everybody's come in. Thank you very much indeed. So on that, I'll now invite the Cabinet Secretary to wind up and press or withdraw the motion.
Sign off, Convener, I will be very brief. Can I reassure members that this is not business as usual? It is an emergency situation because of the risk to the health, well-being and safety of both staff and prisoners. So doing nothing is not an option. Our hard-working prison staff and their partners need to know that we have their back. They need to know that help is coming. And I understand very well the concerns that have been expressed here today. I would remind people that in terms of those who were released in the first emergency release, and this is the second time we've done early emergency release, the change to the management of some short-term prisoners was primary legislation. It was not a knee-jerk emergency reaction. This is the second time we've done emergency release. When it was done last summer, 2/3 of those who were released were within 3 months of their liberation date. These folks are due to return to their own communities in the very near future. And I just have to make the plea to committee that doing nothing right now is not an option, and in my view would be a complete abdication of our duty. And I move the amendment. I've moved. I've moved.
Okay, thank you very much. Okay, so thank you, Cabinet Secretary. So the question is that motion number S6M, number 19222, that the Criminal Justice Committee recommends that the early release of prisoners Scotland Regulations 2025 draft be approved. Are we all agreed? No. Okay, thank you. We're not agreed. We'll therefore move to a vote. So all those wishing to vote in favour of the motion, please raise your hand. Thank you. All those against, raise your hand. 1, 2, 3. Thank you. There are no abstentions. So, thank you. We have 4 votes for the motion, 3 votes against the motion. Therefore, the motion is agreed. So, are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the affirmative instrument? Thank you very much. And this will be published shortly. So can I now turn to the negative instrument, the Prisons and Young Offenders Institutions Scotland Amendment Rules of 2025. Do members have any comments they wish to make, or are they content that it comes into force? Are members content? Okay, thank you very much. Okay, in that case, we will take a short suspension to change over our witnesses. Thank you. First-tier Tribunal for Scotland General Regulatory Chamber Police Appeals Procedure Regulations of 2025. First-tier Tribunal for Scotland Transfer of Functions and Members of the Police Appeals Tribunal Regulations of 2025. And the First-tier Tribunal for Scotland General Regulatory Chamber Police Appeals Cases and Upper Tribunal for Scotland Composition Regulations of 2025. And can I remind members of my register of interest, I'm a former police officer. So we're joined again by the Cabinet Secretary for Justice and Home Affairs, and I also welcome to the meeting Alistair Thompson, Senior Tribunal's Policy Officer, the Scottish Government, Emma Thompson, Solicitor, Legal Directorate, the Scottish Government, and so I refer members to paper 3. So I intend to allow around about 5 minutes for this evidence session, and so can I invite the Cabinet Secretary to make some opening remarks on the SSI.
Thank you, Convener. This suite of regulations will transfer the functions and members of the existing Police Appeals Tribunal into the Scottish Tribunal structure. The Scottish Tribunal structure was created by the Tribunal Scotland Act 2014, which introduced a new and simplified statutory framework for tribunals in Scotland. The Scottish tribunals consist of the first-tier tribunal and the upper tribunal. The Police and Fire Reform Scotland Act 2012 gives police constables the right to appeal to a police appeals tribunal against a decision to dismiss or demote a constable in rank. At present, police appeals tribunals are administered by the Scottish Police Authority, and the appeals themselves are heard and decided by 3 members who are drawn from a list of independent, legally qualified members, which is maintained by the Lord President. It is proposed that upon transfer, police appeals cases will be heard in the General Regulatory Chamber of the First-tier Tribunal for Scotland. The first instrument before you is the First-tier Tribunal for Scotland General Regulatory Chamber Police Appeals Procedures Regulations 2025. This instrument provides for a set of rules regarding practice and procedure to be followed by the First-tier Tribunal when hearing police appeals cases. The procedure rules are based, so far as possible, on the existing rules of procedure for police appeals cases. Opportunity is taken to update some rules, for example, around electronic signing of documents and the electronic sending of documents. To aid consistency across the Scottish tribunals, some rules that apply to all chambers in the Scottish tribunals have been added. For example, the overriding objective to deal with cases fairly and justly is included in the updated set of procedure rules. The Upper Tribunal for Scotland has an existing set of procedure rules, and these are to be used for any police appeals cases that are to be heard in the Upper Tribunal. The second instrument is the First-tier Tribunal for Scotland, Transfer of Functions and Members of the Police Appeals Tribunal Regulations 2025. If passed, this instrument will transfer the functions of the existing Police Appeals Tribunal into the First-tier Tribunal, and the instrument allows for the existing members of the Police Appeals Tribunal to be transferred into the Scottish tribunals as legal members. The regulations will also make transitional provisions to ensure that any live appeals before the existing tribunal are transferred to the First-tier Tribunal. The third instrument is the First-tier Tribunal for Scotland General Regulatory Chamber Police Appeals and Upper Tribunal for Scotland Composition Regulations 2025. If passed, this instrument will make provision for the composition of the First-tier Tribunal and the Upper Tribunal when hearing any police appeals cases. The existing composition of 3 legally qualified members is maintained for the First-tier Tribunal. The composition rules for the Upper Tribunal are drafted in such a way as to allow the President of Tribunals flexibility when determining the composition of the Upper Tribunal. If these instruments are passed, the Scottish tribunals will be able to hear such appeals from 29th of December 2025, The Lord President and the President of the Scottish Tribunals were consulted regarding these draft sets of regulations in line with the requirements of the Tribunal Scotland Act 2014. Feedback provided was used to further inform the development of these regulations. Public consultation that included these regulations was also conducted and closed on 22nd January 2025. It is the case that these three instruments will enable the Scottish tribunals to hear these appeals, and I understand that the DPLRC considered these regulations on the 30th of September and that no points were raised. Thank you, Convener.
Thank you very much, Cabinet Secretary. So, can I invite questions from members? And I'll bring in Pauline McNeill.
Thank you very much. I don't know, Alistair Thompson, it may be more appropriate to ask you, because it's just about the waiting times and just the current structure, if that's okay. So I understand what we're being asked to do. Will it change the waiting times for these police tribunals if it's transferred, the functions transferred over?
It shouldn't have any effect on the waiting times. Currently, the appeals are administered by the Scottish Police Authority, and upon transfer, they'll be administered by Scottish Courts and Tribunal Service. It's important to remember that the Police Appeals Tribunal is a very low-volume jurisdiction.
Right.
So there's, since 2013, there's only been 22 appeals that have made it to the Police Appeals Tribunal. So there's under an average of 2 appeals per year. So we don't have really robust data on waiting times because it's such a low-volume jurisdiction. But it shouldn't affect waiting times for appellants. And the procedure rules detail timescales for people to provide responses and for the Chief Constable to provide a reply to the notice of appeal from the appellant.
Thanks, that's really helpful. Just lastly, so I noted that the existing rules updated will apply in relation to the upper tribunal, where the chair will have some flexibility in appointing members to it. Can I presume that it would be expected that they would be appointing people that are familiar with these rules? Have I had training in the specific police rules?
Because the upper tribunal will only hear questions on a point of law, the upper tribunals are even more experienced members of the judiciary, tending to be sheriffs and senators of the Court of Session. So they'll have expertise in public administrative law and dealing with judicial reviews and these types of matter. So they will have suitable expertise to deal with the cases.
That's great. Thank you very much.
Any other members wish to come in? No? No? Okay, thank you very much. So our next item of business is to consider motions to approve the affirmative SSIs on which we've just taken oral evidence. So can I invite the Cabinet Secretary to move motions S6M 18945, S6M 18946 and S6M 19179 in the name of Siobhan Brown and make any brief additional comments she wishes to make.
Moved on block and nothing further to add.
Thank you very much. Do any members wish to come in with any further points? No? Okay, thank you. So can I invite the Cabinet Secretary to wind up and press or withdraw the motions?
Pressed.
Thank you very much. So the question is that motions S6M 18945, 18946 and 19179 be approved. Are we all agreed? Yes. Okay, thank you very much. And are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the affirmative instruments? Thank you very much. Okay, that will be published shortly. And so we'll now take another short suspension just to allow for a changeover of witnesses. Thank you very much.
Thanks for your indulgence, Convener. Thank you.
Okay, thank you, members. So our next item of business today is to continue scrutiny of the Prostitution Offences and Support Scotland Bill. So we will have one panel of witnesses today, and I intend to allow up to 90 minutes for this panel. And I refer members to papers 4 and 5. So I welcome to the meeting, first of all, Dr. Nina Vuala-Yarve, Assistant Professor in International Migration at the London School of Economics, Ruth Breslin, Director of the Sexual Exploitation Research and Policy Institute, Republic of Ireland, Dr. Larissa Sandy, Associate Professor of Criminology, University of Nottingham, and joining us online is Professor Joe Phoenix, Professor of Criminology at the University of Reading. So a warm welcome to you all, and thank you to those of you who were able to send in written submissions. So just before we start, I remind everyone that we're here today to look at the provisions in the bill, and I'd like questions and answers to stay as focused on the provisions as much as possible. So can I begin by asking a pretty broad opening question, and I'll maybe come to Nina first of all. I'll work across the room and then I'll bring in Joe Phoenix. So I wonder if I can start off by asking you what your overall views are of the bill. Is there anything in the bill which you particularly agree or disagree with and which you think could be improved? So, Nina, over to you.
Thank you, and thank you for giving the opportunity to talk here about my research. So there are elements of the bill that I warmly support, such as quashing the historical convictions and moving the penalty for soliciting, and of course, general support measures for sex workers and people in the sex trade. And I hope later on we can talk about what kind of measures would be effective based on evidence. But I strongly oppose the criminalisation of sex buying based on my research among sex workers and people in the sex trade, police and social workers in the Nordic region. I conducted 3 years of ethnographic participant observations, and this research also includes over 200 interviews, most of which are with people who sell sex. And the reason why I oppose this law on criminalising the buying of sex is because of the harms that it produces to people in the sex trade. And this is what I evidence in my research. So introducing the aim to abolish commercial sex through criminalising of buying does not increase the policing of sex buyers primarily, but it targets sex workers. So that's where the police finds sex buyers. And also it offers this kind of like criminal model instead of a model that would focus on social support. So for example, Sweden invested quite a lot of money on policing, but there was no increase in investment in social services when this was introduced. So the sex buyer law in itself exposes sex workers to violence and exploitation because it reduces the negotiations negotiation space and safety practices that sex workers can have. It also produces overall stigmatization, increased stigma and marginalization in the society that has broader effects on their everyday life. We can see, like in the Nordic countries and also in other countries where this model has been introduced, such as France and Canada, that the overall goal becomes the abolition of commercial sex, and this is done through policing of sex workers. In the Nordic region, the police uses other laws around commercial sex, such as immigration laws and pimping laws, to forcibly evict and deport sex workers, and in this way try to squash the market. I also want to say that 98% of my participants oppose sex buying law because they wanted to sell sex without criminal penalties and in peace and in safety, and they saw how this law affected their lives. And I want to also highlight that there's no evidence on the positive outcomes of the Nordic model policies. The Swedish state claims that this has a positive effect and it has reduced commercial sex, etc. But we have to remember that this law has become part of Swedish foreign policies, part of its national branding, and it has extensively tried to kind of export this model abroad. And the reports that we have from Sweden, they have no conclusive evidence that this would have actually reduced the market. We rather see a transfer of market from the street and kind of visible arenas to online and indoor spaces. And like I already said, we can see similar results from France, Canada, Ireland, and Israel, where the law has been implemented, and the results are increased violence, increased disruptive policing of sex works, use of other laws around commercial sex or taxation or these things to squash the market, and more importantly, worsened relations to the police, which mean that sex workers are less likely to report crime and also are afraid to go forward when they experience exploitation and crime because of the consequences it might have to them.
Okay.
I'll finish here, and I'm happy to answer to any other questions you might have. Thank you.
Okay. Thank you very much. A very comprehensive opening comments. Thank you, Nina. So, Ruth, I'll bring you in.
Thank you. Thank you so much to the committee for inviting me to attend and share our evidence from Ireland. So I'm with the SERP Institute. I've been writing and researching on prostitution and sex trafficking for about 17 years now. But just a little bit about us in the Institute. So we began as a research programme in 2017 in University College Dublin. And about 2 years ago, we transitioned out to be an independent research and policy institute, focusing on all aspects of commercial sexual exploitation. So during that period, we've done about 8 studies on the sex trade in Ireland. So we really have developed our knowledge and expertise during that time. We focused on a number of different perspectives: the health impacts of prostitution for women in the Irish sex trade, the impact of the COVID-19 pandemic. We've done many interviews with women to understand their experiences into the trade, through it and out the other side, so for women who have exited or left the sex trade. And we also did a big piece a number of years ago looking at essentially the legislation in this context, the legislation as it has been operating in Ireland. And there we have our kind of Irish version of the Equality or Nordic model. So I'm very keen to share some of the lessons here with the committee today of what we've learned through that research and our experience in Ireland, including some of the pitfalls, you know, some of the areas where the legislation maybe hasn't worked for us that perhaps are pitfalls that Scotland could avoid. Our legislation was reviewed by our Department of Justice. That review was published earlier this year. That it's very clear that the review says that the legislation is in fact making progress towards its objectives. So I just want to remind us, because I think this very much connects to what you're planning here in Scotland, about the kind of multi-purpose law that we're talking about. The law has a range of different purposes, and certainly when we were developing the law in Ireland, when you know the government and the ministers were looking at developing this legislation, they were thinking about a number of different purposes. So the first is the protective purpose, and actually I have to say, based on the review and the evidence we've gathered, this has actually been the most successful aspect of the legislation in Ireland. It has totally changed the way that the sex trade is policed, but particularly how those who sell sex are policed. So the police changed from a very punitive approach that existed before to this very protective approach, where everyone in the sex trade, regardless of their circumstances, is approached as someone who's vulnerable. And that's because it's recognised that the sex trade is an extremely violent and vulnerable place to be. So, in fact, despite what has been said previously, positive engagement with the police has greatly increased, and women are far more often coming forward when they're experiencing violence within the trade. And I suppose it's also important to say that all sex trades, regardless of their legislation, are inherently violent. So we have seen violence before the legislation, we see violence that continues, but the legislation has not led to an increase in violence. And that's been suggested before, and I think on the last day that the committee heard evidence, and I just want to correct that, that's not the case. The punitive aspect is where Ireland has struggled, so the targeting of the buyers. Yes, buyers are criminalised, but there have been a number of implementation problems in this area, and on Garda Síochána, our police, are very honest and upfront about that, the difficulties in actually securing convictions. So I think that's an area, I can say a little bit more about this as we get into the questions, that's an area where we struggled. However, there is also a deterrent purpose to the legislation, and actually that's been quite successful in Ireland overall, this understanding that the state has said that it's not acceptable to purchase sexual access to the body of another person, particularly when in almost all cases that person is somebody who's much more vulnerable than you. So we have seen that our legislation has been able to hold the size of the sex trade at bay. So despite many push factors over the last few years that have happened internationally to push more women into the trade, such as the COVID-19 pandemic, such as various humanitarian crises, wars and conflicts, our sex trade has remained static. The issue of scale in this area is really important, and I'll refer you in a little while to some of the evidence I shared on paper here. I have a two-pager that I've shared with everybody. We see a link between, I suppose, having the Nordic model in place and a smaller sex trade, and at the same time, anywhere where another model such as decriminalisation or legalisation is introduced, we see a growing and expanding sex trade, and the figures are very clear about that. So I think we're confident that we are holding the trade at bay, and we also have seen progress in the kind of normative and declarative purposes of this law. So an understanding in society in Ireland that, again, as I said, the purchase of sexual access is not something that can be sanctioned by the state. So I've made a number of very broad statements there, but I'm hoping through our questions that we can dig down a bit more deeply. And I want to just put on record, or the record to reflect some of the things that have been said about Ireland previously here are not the case, and perhaps talk a little bit more about the data that I've shared and some of the visuals I've shared here. So thank you.
Okay, thank you very much indeed. Just moving swiftly on to Larissa.
Hi, I wanted to say thank you for inviting me to come here today to speak with you. I have about 25 years worth of research experience with sex workers in Australia, Southeast Asia and the UK. I'm going to speak mostly of my experience in Australia with decriminalisation. I support some of the aims in the bill. The quashing of historical convictions is very important, so I do support that. I also support the measures that are in there around support provisions, but I have some reservations about that as well, which I'm happy to go through as part of my evidence. I support the repeal of solicitation laws as well, and I'll go through that in my evidence. I really can't support, though, the criminalisation of clients that comes in with this bill. Now, contrary to what was just sort of said in Australia and in New South Wales, decriminalisation actually changed the approach of policing, and it was around policing sex work as work and seeing sex workers as workers and having labour rights within as well, which did totally transform the way the industry was policed and the way workers also then worked with police and reported as well. Another reason why I think there's very strong support for decriminalisation, about 10 years ago, The Lancet published an absolutely landmark scientific study on HIV and sex work. The studies actually showed that decriminalisation would reduce HIV infections by about 33 to 46% globally in the next 10 years. The promise of that has not happened because we have not seen decriminalisation coming in some places. Some of that has been because of client criminalisation as well. And we have very little evidentiary support that it achieves the aims that it sets out to do. Australia remains one place where states and territories are actually pursuing more evidence-based policy and policy making. We've got several jurisdictions that have just recently decriminalised sex work. That includes the Northern Territory, Victoria and Queensland. Western Australia, I believe, is also currently considering decriminalisation as well. There has been, when decriminalisation has been introduced, I can talk about the evidence, there has not been an increase in the industry or the number of workers either. So I can expand on that as part of my evidence. What we do have is very strong, robust evidence on the harms of criminalisation. It is the research that we have on that is extensive and it is robust. Here I can share with the committee, I will point them to a 2018 study that was done by Platt and colleagues. They undertook a systematic review of 40 quantitative and 94 qualitative studies published between 1990 and 2018 on sex work-related legislation and policing and health outcomes. It's one of the largest systematic reviews we have on sex work research. It is methodologically robust and rigorous, and it found that all forms of sex work criminalisation, including the criminalisation of clients, actually did not prioritise sex workers' health and safety. And that's particularly so for more marginalised sex workers as well. They did find that sex work decriminalisation actually worked to facilitate sex workers' access to health, to services and to justice. So I'm hoping that I can share more about my experiences and experiences of sex work under decriminalised settings in New South Wales and New Zealand in my evidence today. Thank you.
Thank you very much indeed. So last but by no means least, I'll bring in Joe Phoenix. Joe.
Hi, can everyone hear me okay?
Yes, we can hear you. Thank you.
Okay, thank you. And thank you very much for the invitation to speak. Before I say what I think about the provisions, I just want to note that I've been doing research in this area since 1993. But around 2010, I stopped doing research in this area. And I stopped for a very simple reason. And that's that I began to feel as though the research base itself was becoming moribund, which I'll talk about in a second. Having said that, I have kept my eye on the research as it's come through. So I've been involved in one way or another thinking about prostitution policy reform for a very long time. If you had asked me what my views were on this bill maybe 15 to 20 years ago, I might have said, similarly to some of the panel members, that I didn't support the criminalisation of sex purchasers. However, I have changed my mind. And so to cut to the chase, I support all aspects of this bill, not just warmly, but very strongly. And the reason for it, I'm happy to go into detail over any of this, is because we know many, many things. After 35 years, we know many things. We know that prostitution is both work and violence. It's not just one thing or another, despite what people will tell you. We know that it is an incredibly diverse industry that has people working from the street right the way up into hotels and so on and so forth. We know that prostitution has always and already been connected to illegal markets, organized crime, and so on. We know that the effects of prostitution can devastate the lives of the women and girls. We mustn't forget the girls here that are involved in it. We also know something else, that at least in Scotland and in England and Wales and Northern Ireland, we have benefited from 20 years worth of reforms to prostitution policy, right? We are not dealing with the same landscape that we were when I began. Now, I'd say that because when I began research in this area, England and Wales had something just over 10,000 convictions for soliciting and loitering for the purposes of prostitution. In 2021, which is the latest figures I looked at, there were only 301, right? That's a massive change over a relatively short period of time. And what I want to suggest is that what we've seen over the last 20 years is a de facto decriminalization of soliciting and loitering for the purposes of prostitution, but at the same time that no support was put into place. And so you end up with this Janus-faced approach to dealing with prostitution generally that distinguishes between forced and voluntary prostitution, that distinguishes between a rhetoric of victimization for the women and girls involved, but doesn't necessarily provide the support measures. Now, I personally think that we are seeing the legacy of this in terms of the grooming gang, I knew I was going to fumble on that, the grooming gang crisis in England, because what we saw there was a reformation of policy to do with girls in prostitution that was based on a rhetoric of victimhood where there was no kind of corresponding support services. So to kind of wind up, the thing I support most about this bill is, in fact, the criminalization of the purchase of sex at the same time as making support services statutory, or the right for support services statutory. I'm happy to talk much broadly, or as broadly as you like. I'm happy to take questions on why I think that the evidence that has been presented to the committee is highly problematic. But I'll end there because I know that you want to ask questions.
Thank you very much, Jo, and thank you all. I think these were extremely helpful opening remarks, even though there are different views in the room, but I think you articulated your views very, very well in a very helpful way for members. So I am going to move on. I'll bring in Deputy Convener just in a moment. I would ask, just in the spirit of getting through as much as we can this morning, for fairly succinct questions and answers. I know that's sometimes difficult. And just to draw members' attention to some of the research and studies that have been referenced this morning. Obviously, we can access that on behalf of members if they would find that helpful. So with that, I'm going to hand over to Liam Kerr, and then I'll bring in Sharon Dowie.
I'm grateful, Convener. Good morning to the panel. I will ask two questions, but I will give you each an opportunity to respond, starting with Dr. Vuolijärvi. Nina, could you tell us, I want to pick up your point about evidence, which you raised in your opening remarks. Can you tell us, what does the evidence tell us about the impact of the Nordic model, so the criminalisation of the buyer, on the number of people involved in prostitution, the experience of people involved in prostitution, so that's safety, stigmatisation, the access to support, and the involvement of organised crime, including trafficking in prostitution?
Thank you. Thank you for this question. I'm really happy that you brought up the evidence, because that is something that is very difficult to get from this trade, like numbers. We are all the time asked, like by journalists, policymakers, and so on, to give us numbers. And it's really hard to assess the extent of the sex trade or extent of trafficking. It's really hard to make comparisons because, for example, trafficking can be registered in different ways. Also, it is a crime that is very much dependent, its detection is very much dependent on how much police investigation goes into these crimes. So what we know from Sweden when it comes to the level of people in sex work or prostitution, we have some evidence that street prostitution has decreased by 50%. That is quite well documented. The problem, however, is that the law came into power in 1999 when kind of online platforms and internet kind of rose. So it's hard to say what exactly happened there, but like we can see a high increase in online advertisements. So, for example, from 2006 to 2014, and this is we see a increase from 304 ads to 6,965 ads. Of course, this might mean that people have several profiles and so on, but like we can see that there is a clear transfer from the street sex work to online, and this is something we evidence everywhere. So this makes it really hard to assess it. And the problem with Sweden is also there was like no effort to make kind of before and after comparison, that there would have been kind of like a systematic effort to look at the changes. So if we think about other countries where this legislation has been implemented, the only place where we have kind of reliable knowledge before and after is Northern Ireland. And there, Peter Bacchus's research from Manchester University shows, and he compared the number of advertisements, that there was a decrease in the beginning in the advertisements, but it came back to the same levels 18 to 24 months after. So there's kind of a scare effect, and then it continued. But coming back to Sweden, so on the trafficking, there is no kind of data collection that could show what has happened with levels of trafficking due to this law. The police claims that it creates a hostile environment. In my field research, I evidenced the police using pimping law and hotels policing sex work, making it more difficult for sex workers to operate on their own. So finding apartments, finding places to sell sex, which force some people to turn to people who know that the apartments they are renting are used for commercial sex, which meant that they ask higher prices because they're taking a risk of being accused of pimping. So in a way, I see that the way the police enforces the law in Norway and Sweden actually increases the vulnerability for exploitation. About the experiences of sex workers under this law, there are many kind of qualitative studies that show how sex workers experience this law, and I think it's quite reliable. So it hampers sex workers' safety practices and makes client screening difficult because clients don't want to identify themselves. Rather, like, sex workers need to show that they are actually real people, that they are not police, and so on. Many of my interviewees talked about these issues. Also, there's more demand for outcalls, meaning that sex workers go to places that they don't know what's in there. So, for example, private apartments, so you don't know, you go into a place, you don't know how many people there are, who is in there, instead of, like, for example, the client coming to your place where you can be aware of the surroundings, and which is, of course, safer. Like I said, street sex work is quite a minor section nowadays, but, like, the street workers I talk with said that on the streets, client hurry negotiations, so you have less time to assess the client before you jump into the car, for example. Also, they want to do the transaction in further locations, which is a risk, or instead of, like, or in the car or in further locations that are unknown to the sex worker, instead of, for example, a hotel or other kind of, like, safer location. So in these ways, we can see how it increases individuals' exposure to violence. Yeah, maybe I stop here. I would also say that the policing involved in this has, in the Nordic region, very severely endangered the relation between the police and the sex workers. And, like, generally, sex workers said that they don't want to go to the police. They were worried about other problems, losing their apartment, being deported, being reported to the social workers, which mean that they would get in trouble with the custody of their children, and so on. So, and I think that was a really big risk for sex workers when it comes to violence, because during my field work, I also evidenced that some criminal elements use the knowledge that the sex workers won't go to the police to target sex workers, for example, on robberies and so on.
I'm very grateful. Dr. Sandy, I think you would take a similar view of the Nordic model aspect of this. Do you have any evidence to add to Dr. Wallijärvi?
If I can speak from the experience in decriminalised settings, I think really would support what Nina was talking about there. In New South Wales, Australia, we have very robust longitudinal data on the three questions that you asked. In one of the largest studies that was done was 2012, was commissioned by the New South Wales Ministry of Health, a very comprehensive report on decriminalisation, carried out by the Law and Sexual Health Team, that's LASH, at the Kirby Institute, the Law Department of the New South Wales, the University of New South Wales, and the Sydney Sexual Health Centre. I can share that report with the committee if you would like. Over 200 sex workers were surveyed. They also analysed the Sydney Sexual Health Centre database from 1992 to 2009. They did research with New South Wales councils. That's how decriminalisation works in New South Wales. As I said, it's a very rigorous, high-quality piece of research that was carried out by global experts. That LASH report concluded that the size of the sex worker population in New South Wales had not increased since decriminalisation was introduced. It's marked at 1995. It was gradually brought in over a period starting from the 1970s. In 2017, Rissell and colleagues confirmed the findings of that study again. They did that with buyers of sexual services. The study that they did was based on over 8,000 interviews with men in New South Wales. The size of the sex worker population remained steady since the introduction of decriminalisation. If I can comment on the demand, the big thing that is often an argument about this, the Nordic model, is the demand for sexual services. Demand for sexual services in New South Wales has been no different with the introduction of decriminalisation to other states and territories. While women and men purchase sexual services, a lot of research in Australia has been with Australian men. By world standards, Australian men are pretty infrequent consumers of sexual services. Rissell and colleagues did a study in 2003 with Australian men. 2.3% of New South Wales men reported buying sex in that last year. 16% reported ever buying sex. That was the same as Australia overall for New South Wales men, so no difference with that at all. We also see, and this is where I think Australia is very interesting, in 2010, Harcourt and colleagues compared the Perth, Melbourne and Sydney sex industries. It's a very interesting study because sex work is criminalised in Perth. So that works through de facto legalisation, where we have police-operated illegal brothels that operate in the city. At the time of that study, Melbourne had legalisation, which resulted in a two-tier legal and illegal sector, and Sydney was decriminalised. So it's a very interesting study. They found a very active and diverse sex industry in each of those three cities, and on a per capita basis, the number of brothels was about the same in each of those cities. So their finding was very consistent with population-based data on rates of buying sex with the within the Australian population as well. So that led them to actually make the conclusion that the legal climate had no impact on the prevalence or the purchase of commercial sex. What it did have an impact on was workers' health and safety and businesses as well. It also had an impact on rights and legal protections and accessing health programs. In Melbourne, with licensing, there was an illegal sector, so the studies sort of say there's something between 30 to 70 illegal businesses that were operating. Those businesses weren't supported by outreach or health services. They were pretty much all invisible and inaccessible to health promotion programs. Police-operated illegal brothels in Perth meant reduced access for health services and peer educators as well. In Sydney, the research showed that SWAP, that Sex Worker Outreach Project in New South Wales, so SWAP NSW, had access to all brothels and all sex premises. So while the legal context didn't seem to matter, that's what their research was showing, it didn't have an impact on demand. It did affect health promotion programs within the sector, and it actually introduced isolation from peer education and support in Melbourne and Perth. It also was a significant issue in ensuring occupational health and safety and health promotion. We have similar results coming from New Zealand as well on the size of the sex industry with decriminalisation. So the Health Research Council and the Ministry of Justice both commissioned two projects. One was in 2007, the other in 2008.
Dr. Sandy, forgive me interrupting. The question that I need evidence on just now is less so on the decriminalisation and just specifically on the criminalisation of the buyer. What's the evidence on the impact there?
The evidence on the impact for the criminalisation of the buyer is most of that policing happens through sex worker surveillance, right? And it forces sex work further underground. So the evidence that we have shows that it is a form of indirect criminalisation because it is through clients that sex work is criminalised. You will also see the introduction of brothel keeping legislation, which makes it almost difficult or impossible for sex workers to be able to work safely as well. So that is what the research shows. We have a very different picture with decriminalisation and models of decriminalisation.
I'm very grateful. So, Ruth Breslin, then, you would take a different view of the Nordic model, the criminalisation of the buyer. We've just heard evidence that tends to a view that the criminalisation of the buyer is not going to achieve the ends of the bill. You would take a different view.
Yes.
What's your evidence?
I think before we talk about the criminalisation of the buyer, it's important to understand, I suppose, the nature of how the sex trade is operating. And I'm speaking here, obviously, from the Irish experience. But we also need to think about, who's in there, who's selling sex. So over the course of really the last decade, we've developed a profile of who is involved in prostitution in Ireland. It is, of course, primarily women. So this is a highly gendered trade. The vast majority of those selling sex are women. The vast majority of those buying it are men. Every day, about 800 or 900 women are advertised online in Ireland. Well, at least there are 800, 900 advertising profiles. Less than 1% of those are male. I suppose it's to understand, and I've shared this in the paperwork, we've developed this kind of bell curve profile where we have found that probably about 10 to 15% of the women in our trade fit that very classic definition of having been trafficked under the Palermo Protocol, which is what our kind of legislation is linked to. They have been brought into Ireland, they're migrant women, they have been forced, coerced, deceived into this situation. Then we have a small group of approximately 5% who would very much say, this is something I chose, this is labour, I had many choices, but this is what I decided to do in order to earn money. Many of them would describe themselves as sex workers, but they are quite a small percentage. And then right in the middle, we have this big, what we call the vulnerable majority of about 80% of women who would say, yes, I chose to be involved in the sex trade, but when you look at the circumstances in which they have entered, it was a choice from no choice, from a really constrained circumstances. So again, a lot of these women are migrant women who've arrived in Ireland with very limited English and very limited kind of social capital, and their families are back home in South America, in Asia, in Africa, desperately waiting for the money that they're going to send from Europe. So these women have no choice but to get into something where they can earn money as quickly as possible. And they remain kind of in a very vulnerable and precarious situation. So I suppose we've interviewed many women who are involved in prostitution right now, and also women who have come out the other side and who have exited. And, most of those women are not describing themselves as sex workers. They will say, many of them, yes, I'm working. They will often say, I'm escorting, because our trade is almost entirely indoors and online. So they'll say, I'm escorting, but they don't adopt this idea of sex work as an identity. They say, prostitution's not who I am. It's just something I have to do. So I suppose that's thinking about the profile of the women. Then we think about the profile of the buyers. So the profile of the women are majority migrant, as I said, being drawn in, very vulnerable in so many different ways, including many not speaking English, experiencing poverty, experiencing coercion, particularly obviously in the case of the trafficked women. And then we have the buyers. Most of those men are Irish, they're middle class, they enjoy incomes above the average, they're well educated, and most of them are in a relationship. So in our work, this is where the understanding of sexual exploitation comes in, because those men are using their kind of superior status in society and their superior economic power to purchase sexual access to the bodies of vulnerable women who generally do not enjoy the same status and the same power. So we always see this in almost all circumstances. We see this power imbalance between the buyer and the seller, and this we feel is where the sexually exploitative context comes in. And I would also add to that I've interviewed so many women who've told me that, of course, this is unwanted sex. They don't want to be going out every day and having sex with multiple unknown men that they haven't met before, but the money is what's holding them there. They're desperately in need of the money, and so they are exchanging sex in order to get that money that they desperately need.
Ruth Breslin, forgive me interrupting, but I'm conscious that I'm monopolising the floor here. What happens then, given that context, what happens if this committee or this bill criminalises the buyer?
Sure. So I think what has happened here, and I think when Ireland came to develop this legislation, they started to understand that kind of exploitative dynamic that was going on there. So the idea was, you know, as I said, the declarative and normative purpose of the law to send that message to men that no, this is not acceptable to purchase sexual access to the body of another person, particularly one who's more vulnerable than you. So that is exactly what we did in Ireland. And I suppose this is one of the weaknesses for us in terms of our implementation, in that although we have had very few successful prosecutions, at least there has been the case, as I said, that buyers are aware that the law now targets them. The women are also very aware of that themselves. So the women report really quite positive experiences now of the way that prostitution is policed in Ireland. So the police entirely changed their policing approach to shift the burden of criminality away from the women and onto the shoulders of the buyers and, of course, the organised crime gangs that run the trade, because you asked about organised crime and trafficking. You know, the trade is rife, and it's still the case to this day, rife with the involvement of organised crime. So the idea was, with this legislation, was to place the burden of criminality on those shoulders. So I think you can see that in some of the data I've shared. The first bar chart I shared shows the decriminalisation of those who sell sex, and you can see that has fallen year on year, even slightly before the legislation came in, when people were starting to understand that criminalising women was the wrong thing to do. And then in terms of the criminalisation of sex buyers and profiteers, in the second graph that I've shared, you can see that the red bar charts show the numbers going up as the policing attention, and these are official crime statistics, as the attention of policing is placed on the buyer. One of the issues we've had with our legislation is that it's a summary fine on conviction. So what that means is that the buyers are required to go to court to kind of plead their case. And what we found in many instances was in the intervening period, so there were over 300 buyers kind of progressed against in the recorded crime statistics. About 160 made it to court, but only 15 convictions, because in the meantime the buyers armed themselves with good lawyers and were, you know, able to argue their way out of the situation. So what we've done, I suppose, in Ireland with the review is we've recommended ways to address this. So the Department of Justice in Ireland is now considering on-the-spot fines for buyers, so that the criminalisation element can essentially be realised a little bit more easily.
Okay, I'll thank you very much for that. I think you'll be probably asked about how this can be made better going forward. I'll just bring in Professor Phoenix finally, just with a straight question then. If this bill comes in and criminalises buyers, what's the impact of that based on the evidence that you've seen?
After 35 years of paying attention to the evidence here, there will be one direct impact. It will resolve some of the Janus-faced policing that we have. So let me just talk you through that for a tiny bit. Where we have any regulatory framework which distinguishes between voluntary and involuntary prostitution, that forces the police necessarily to focus on the women involved in prostitution to assess whether or not they are voluntary or involuntary. If you remove that altogether and say, you know, it's decriminalized, and in fact, we're just going to criminalize the purchasers of sex, then it forces police's attention towards the punters, the purchasers of sex. So the problem that we have around the policing of prostitution, you've heard from, you know, both from all of us today, that there is a real problem around the policing of prostitution. That's the thing that actually unites all of us, weirdly. The evidence given by my other learned colleagues there have talked about the challenges of implementing the criminalisation, how the police have failed in Sweden, etc. We know that the black box underneath all of this, if you like, is what do the police do? And I think if you remove the necessity of the police to try and assess whether somebody is voluntary or involuntary, then it actually just removes that altogether and it refocuses the attention. And, you know, Ruth's evidence kind of provides some helpful insights there. Can I just come back, though, to one thing about the evidence base here? I said earlier that I stopped doing direct research in this area. And I stopped doing direct research in this area because of the nature of the research that was being done. And in my mind, what we have is a real problem with the evidence base, one way or the other. And the problem that we have is that research tends to proceed from an a priori assumption about what prostitution is. Now, if we start from the presumption that prostitution is sex work, then every part of the research process thereafter is going to lead to what we call in academia a confirmation loop. And what we have seen consistently over the last 15 to 20 years is research that literally just reproduces its own assumptions continuously, which is a real problem. So it means that for all of you, trying to pick through that evidence is challenging, to put it mildly. Which is why I kind of go back to some really basic principles. And that's, what are the police going to assume? Do they need to focus on the women? Do they focus on the punters? Anyway, I hope that's helpful. I'll keep my comments relatively brief.
It's all very helpful. I'm very grateful to you all. Convener.
Yeah, I mean, it is fascinating. It's very helpful. But I would, again, urge succinct responses, if that is possible. So I'm going to bring in Sharon Dowie and then Jamie Hepburn.
Okay, good morning. I'm going to ask you about assistance and support. And in your opening statements, a lot of you actually mentioned that. So the importance of support for people who are or have been involved in prostitution has been highlighted in evidence to the committee. So what should the support look like? And the second part of that is, are the provisions of this bill and this issue helpful? And are you able to comment on the estimated cost of providing support as set out in the bill's financial memorandum? So if I could maybe start with Nina on that one, please.
So you want to know what kind of support would be needed?
Yeah.
Based on my research. Yes, thank you.
Yeah.
So I think like when it comes to services for sex workers, I think we have all established here that people who sell sex workers are kind of a very diverse group of people. So, and often they have various needs and also understandings and interpretations of commercial sex. So what is needed is that the services are non-judgmental. So they don't assume that sex work is violence against women or that it's necessarily a work that you identify with, but rather taking an open view on the interpretations of people who sell sex on their situation. And what my research demonstrates that there is a significant need for various types of support services. Many people wanna go away from sex work. It's not a long-term career choice, but this often requires several types of support that is needed, such as housing. That's very important for some people, and income support. Also, vocational training services are very important for people to acquire skills. And also, that the kind of vocational services are directed to professions where you can actually earn money. Because many people who do sex work, especially migrant workers that I met a lot, they have families to support in their home countries. So doing a nail salon work is not maybe the option. They need something that can actually support themselves and their families. Of course, mental health assistance, help with drug use, and so on. And I think it's very important that these support services are low threshold, non-judgmental, and starting from the viewpoint of the person who's accessing these services. So a condition of stopping sex work should not be included or condition for accessing services like it has been, for example, in France, where this a Nordic model has been introduced, because, like I said, many people need to feed their families and children, pay rent, and so on. So kind of having enough economic support is important, and sometimes, doing sex work while you transfer to other forms of labor might be important. And I think also, with the current bill, I've understood that there's no money earmarked to the services. So what we have seen in, for example, in Sweden and in other countries is that, if the money is not earmarked, it might just go to the policing of sex work. So I think that's very important to think, that we just don't introduce another criminal law without, really thinking what is needed on the ground. Because many of us have said here that, many people engage in sex work because of the need of money, because of poverty. So, criminalizing the buying won't remove that need for money. So yeah. And I think one thing I want to emphasize in addition is that, when these services are planned and executed, I think it's extremely important to start from the viewpoints of people who sell sex and sex workers, so that, we don't end up making policies and services that don't come from the needs of the people on the field, because this is what I see very often happening. Thank you.
Thank you. Dr. Sandy, do you want to?
Yes, very happy to. Just to follow up, I won't reiterate what Nina said. I fully agree with all of that. I think based on my work, so one of the large projects I did in Melbourne was around exiting or transitioning programs for sex workers. That involved a very large project looking at best practice and trying to establish what best practice was in service provision, and this was with a Melbourne-based sex worker support agency that provided an exiting program or a transitioning program for sex workers. So we reviewed the evidence base, but we also did that work with sex workers as well. The part of our key finding was you absolutely need a needs assessment, and that needs assessment needs to be with sex workers about the supports that they need. It needs to be a very diverse needs assessment as well, because there are a very diverse range of workers and a diverse range of needs for all of those different workers as well. So the first thing you would need to do would be to establish that comprehensive needs assessment as part of it. As I said, that work needs to be about not leaving sex work as the mainstay. It needs to be about providing support and services for sex workers. So it can't be conditional on sex workers needing to either reduce their hours or to exit as well. Those services need to also be part of general services that are provided by sex worker organisations that are also funded as well. And so quite significant funding is needed on that. I can go into that a little bit more. It needs to be based on quite a few different things. And so a lot of these programs, we did a literature review of the global evidence base and programs. We found a lot of the programs that are offered come from the point that sex work isn't work. So at best practice, you need to be looking at and understanding sex workers' work. That is how the majority of workers understand sex work. Not all sex workers do see it that way, but it is primarily the dominant view. The other thing with a lot of these programs is that they see sex work as unskilled labour. So it needs to come from the point that sex work is skilled labour as well. And the idea that sex workers have never done anything but sex work. And so, you're kind of starting from this sort of ground zero. That is not the case at all. Sex workers have very diverse employment histories, trajectories, and sex work is just one part of that. As well. So you need to take into account the skills, the education and the experiences that sex workers actually have. The biggest one that we found was actually stigma and discrimination. So what is a barrier for sex workers in accessing services and, in looking at retiring or moving out of sex work and doing other sorts of work is stigma and discrimination that they face in the community. So it's really important that these programs actually address and work with the community to reduce stigma and discrimination. And one of the big things that we noted was the need for this to go into equality legislation, so that within the equality legislation, sex work is recognised as a protected characteristic and occupation, and that gives sex workers access to legal rights under discrimination and vilification laws as well. I'll go on to the funding very quickly now. In Melbourne, I will, because in Melbourne, with the work that was done around the exiting programs that were offered there, it was $4 million Australian dollars that was earmarked by the state government before coming into decriminalisation. and that was to review the services that were being provided, which was part of the work that I did. That included the review of that, the needs assessment, and the funding that was needed to then be providing those services as well. And that was only over a very short period of time. So it does require significant support, resourcing and funding, and that needs to be very long-term funding as well.
Okay. Okay. Do you have anything short to say?
Anything short? Yeah. I will be as brief as possible. I think that it is essential that supports are provided, of course. You know, you're in a situation where women are trying to survive and they're relying on this income, but it's not just them, it's their families, particularly in their country of origin. They're feeding children, they're sending them to school, they're caring for sick parents. So we can't just take that income stream away overnight. So those supports are really important to step in and be able to offer women other options. And I think it's really important. It was suggested here previously that in Ireland the support services require women to leave or exit. That's absolutely not the case. The services are working very much, they describe it as we meet women where they're at. So that might be a woman who's saying, this is what I'm doing right now, I'm happy doing it, it's going well, but I still need some support around that, all the way to women who are like, you know, I really need to get out, please help me. So I think it needs to be a multitude of supports. I think harm minimisation and keeping women safe while they're in the sex trade is really important, but I think that sells women extremely short, because the vast majority of women, and certainly the women I've met, want to get out of the trade as quickly as possible, and they need specialist support to do that. And it's, you know, we did a whole study on women's barriers to leaving and then their barriers to recovering and rebuilding a new life. And the top barrier is not things like stigma. The top barrier is the deep trauma that they've experienced of having multiple counts of unwanted sex, experience rape, sexual assault, violence, beatings, attacks, robberies on such a frequent basis during the sex trade, that when they come to services, the first thing that needs to be addressed really is that deep trauma and helping them in terms of rebuilding their lives and creating new identities for themselves.
You said you had that there was a big cohort in Ireland in the middle that were basically people that had no choice. So do you think if we get the services right, a lot of people would actually leave the sex trade?
I think absolutely women need options, and what they're telling us in the research all the time is not what they want to be doing. They all have hopes and dreams for the future. They have other plans. You know, so many women say that, even unprompted. They will tell me that I wanted to set up my own business. I wanted to go back to school. I wanted to learn English. I don't want to be here forever. So absolutely, I think if you have the right supports in place, women will engage with them, and most of them will not choose to stay inside this very dangerous trade.
Thank you. Professor Phoenix, do you have anything to add?
You'll need to unmute.
Can you hear me now?
Yes, yes.
Okay, yes, I couldn't unmute myself for a second there. I do have something to add. I have only four short points to add. We've heard a lot about diversity. There is diversity, but it's not symmetrical or even diversity. We know from 200 years worth of research into prostitution, if not more, that the vast majority of women in prostitution have come from backgrounds where there's abuse, where there's physical abuse, sexual abuse. We know the vast majority have drug and alcohol problems, have economic problems. We know that at least contemporarily within the UK, we know that some of the social and welfare needs of women in prostitution are profound and complex. So we know that that is the majority. So even though there might be diversity within prostitution, we know that there's an intensity of women with profound needs. We know something else. We know that to deal with the issues that women have, we have to go further upstream and look at the drivers for them. And I would suggest to you that the main drivers are both poverty and male violence against women. So we know if we can address some of those connections with male violence against women and poverty, that we can create support services that actually help women get out of prostitution. But more importantly, if we can divert some of the women who we know have the type of risk factors that are going to be likely for them to end up in prostitution, if we can divert them before they get there, then we do some tremendous work. And I just want to highlight, and I'm happy to send reports about this afterwards, I want to highlight two programs that have been hugely successful down here in England. They were run by the Nelson Trust, by a former woman who was involved in prostitution. One was called the Griffin Project, and the other one was called the Phoenix Project. And the success rate of those projects was phenomenal, absolutely phenomenal. So I'm happy to send information about that. But all I want to do is underscore the fact that what makes the bill that is being proposed at the moment unique, in my mind, is that it puts that support service on a statutory footing. And I think that is absolutely critical, because we know another thing about women in prostitution. We know that when it comes to funding support services, they tend to lose out. They lose out to many of the other needs. They are seen as a forgotten and an easily ignored population, because partly their needs are so complex. All right, that's all. Thank you.
Thank you. If you could send us information on those two projects, that would be helpful. Thank you.
Thanks. Okay, thank you very much. Okay, I'll bring in Jamie Hepburn, then Rona Mackay.
Okay, thank you, Convener. Thank you very much for your evidence thus far. I have a few questions, so I'm just flagging that early. If you can assist me in not extending the patience of the convener and working through them, and that would be.
I wonder if I can also maybe just ask members, just in the spirit of time, if we can come back if we have time. If you want to ask specific witnesses, we don't necessarily have to ask them all, although I'm sure they've all got a contribution to make.
Indeed, that brings me
give you that option.
To my point, Convener, because I'm going to probably draw on the written submission, so I probably will operate on that basis. I suppose the first, and Liam Kerr did kind of touch on this issue in terms of the impact of any legislative change in terms of the safety of those involved in selling sex. And for my mind, that's got to be absolutely paramount in our consideration here. You know, we shouldn't do anything that makes the circumstances more harmful, and anything we do should improve on that. So in terms of the evidence that's been presented, Dr Valerie Harvey, you provided pretty stark information in your written submission, saying that criminalising sex buyers increases rather than reduces harm to sex workers, and this seemed to be based on the evidence you'd gathered in speaking to those involved in selling sex, who cited increased violence exposure and reduced safety practice. It would be helpful if you could speak to that, but then I'm also struck with the point that Ruth Breslin said that's not been the experience in Ireland, so if you could speak to that as well, that'd be helpful.
Yes, like I said in the written statement, like we can see how this kind of will to get rid of commercial sex leads to repressive policing, and this policing is like supposed to target the sex buyers, but they are reached through people who sell sex, because where do you find the buyers? Like, like you find them through people who sell sex. And also this kind of impetus of seeing kind of like sex work as a harm to society has led to this will to suppress the market. And we can see, for example, in Norway that just before the law was implemented, the police engaged in this, what they called the Operation Houseless, which meant to clean the indoor market before the law came into power, because they were worried that it will move indoors. And that practice has stayed with the police. So instead of like, maybe they can catch one or two buyers outside the flat, but after that they will use other laws to forcibly evict, like pimping law, that, saying that your landlord...
Could we come back to police and have a question about police? Yeah. I'm thinking more specifically in terms of the type of incidents around increased violence and more unsafe practices. Could you speak more about that, and I can come back to policing?
Yeah. So if we think about the Sex Purchase Act just in itself, like what the law does, if we don't think about the policing, is that like it reduces the negotiation space of the buyer. Like they can demand less from the buyer to identify themselves, basically identify themselves and are instead forced themselves to, for example, take a picture of themselves with the newspaper of the day, to prove that they are, not the police, meet the client in a place that is not like, let you know in the last minute, or go to the client's houses and so on. So these are all factors that expose people to violence when it comes to the Sex Purchase Act. And also the same goes for the kind of the street actions where the clients are worried about being caught. So they rush the negotiations, they want to go further from the street location and so on. So does this answer to the...
That's helpful. Ruth, you're just saying the exact experience.
One of the things I was mentioning that we've observed in our research is the kind of success of the protective factors of the law in Ireland. So I described that shifting the burden away from the women, the burden of criminality away from the women. And I mentioned as well that the police decided to approach everyone in the sex trade as vulnerable because of the incredibly risky environment that they're operating in. So what's very clear is the approach by police then changed because they moved away from raids, battering down a door and frightening everyone. And the women always told us in the research that they hated that experience. They've moved from that to welfare visits. So this is a much more gentle knock on the door, just to let you know we're the specialist police in this area. We are here if you need us. Here's our contact details. Sometimes on those welfare visits now they're being accompanied by specialist workers from the frontline support services who are not police and who don't represent the state. They're members of NGOs. So if a woman is very wary to want to interact with police, and you can absolutely understand that many of the women are, there's somebody there more independent that they're able to interact with. And it's all about offering support. And what the Gardaí, our Irish police, tell me is very often the women on that day will say, I'm fine, no problems, I'm grand. But they've left their details. They'll hear from that woman in a week, a month, 6 months, a year, when something really serious has happened to her inside the sex trade.
Forgive me, can we come back to that again? I'm actually talking about, does the evidence suggest that there's not been an increase in terms of incidents of violence in particular?
So what I would say in the wider context is because of the violent nature of the sex trade, we looked at the data from before the law was introduced, about 3 years before, and the data since, and the violence throughout that time has remained high but consistent. So there were suggestions previously that there's been a 92% increase in violence. That is just categorically not the case. That statistic cannot be proven in any way, shape or form. So I suppose what the women are saying is that they now feel more comfortable getting in contact with Gardaí, with our police, if they have a problem. Women are also gaining an understanding of the law. So sometimes what sex buyers threaten is, if you don't do this for me, or if you don't give me a discount, or if you don't give me this act that I want, I'm going to call the police on you. And women are now able to say, and women have told me this in interview, no, you're the one in the wrong, I'm going to call the police on you. So there's been numerous interactions and stories that women have told me like that. But a really key change that I want to really emphasise here is women's access to justice. So over the course of the last number of years, before the law and since the law, there's been some very, very violent attacks against women in the sex trade by individuals who go out to target them because they know these are very vulnerable women. So I'm talking robberies, severe beatings, rapes and sexual assaults. And we have documented since 2017, since our law came into place, tens and tens of cases that have come across in front of the courts where those perpetrators are being prosecuted and the women have achieved justice. So the women have now felt comfortable enough to interact with the police, to give evidence and to be witnesses in court. And we've had many successful prosecutions against very, very violent men who, as I say, have deliberately targeted women in the sex trade. That did not happen before 2017, when the women were still criminalised and when there was no way they would interact in a court environment. So we are seeing a very significant increase in women's access to justice, which is extremely positive and just didn't happen before we had this legislation. And I actually, just to add one last thing, I actually spoke yesterday to the head of our Garda National Protective Services Bureau, because the policing of prostitution and sex trafficking is under our kind of protective services within the police. I spoke to Detective Chief Inspector Colm Noonan, and he was letting me know that he has been in conversation over the last few months with Police Scotland about this approach and the whole of the Nordic model that we're using in Ireland. And although we've faced, as I said, a number of implementation difficulties, he, as the Irish Police, is very much recommending this approach to Police Scotland. So those conversations are ongoing.
That's useful. And I take your point about violence. That kind of tallies with evidence we were given at the last session. One witness who supports the bill was making the point, I think we would all understand, that no change can ever make this the selling of sex truly safe. So I take that point. You've preempted a lot of my... Sorry, Dr. Valerie.
Yeah, I just wanted to add that, like, if I'm not correct, please correct me, Ruth, but like before this law was introduced, selling sex was criminalized. So if you remove the criminal penalties on selling of sex, it has exactly these effects. But it has nothing to do with the sex buyer law itself. It's the decriminalization of the act of selling of sex that produces more safety, because then you can report to the police if you are a target of crime, and that's extremely important. And what we see with the Nordic model is that in many cases, sex workers become de facto criminalized through other policing measures. So that's why we are, or I am, against this increasing of criminalization around commercial sex. So this is a thing. And actually, the Northern Ireland Department of Justice has noticed that there is an increase of assaults towards reported assaults towards sex workers. But I'm not an expert on Ireland, so this is just the knowledge that I have of the Irish case. Thank you.
Okay.
If I can make a
of course.
For the case with New Zealand, we have a lot of research that shows that workers felt protected by the Prostitution Reform Act. They were more able to refuse clients. There was less client blackmail, extortion, violence, and of course more workers also reported to the police. So there was a significant increase in access to justice that came through decriminalisation of sex work.
Although of course that's not on the table here. We're not considering that as a legislative proposition. So, but it is still useful for us to understand.
I wanted to present that evidence
that
for the committee to consider.
Ruth has quite kind of preempted my question about...
I think we're all agreed that the women should be decriminalised. Of course they should. They should not be criminalised for the exploitative circumstances that they're in. But decriminalising the buyer and the pimps is a whole different ball game. And two things to say about that very briefly, convener. Thank you.
I wonder if I can maybe just pause you there. I'm just conscious that we've got a number of other members. What I would like to do is bring the other members in. And then I'll come back to Jamie Hepburn's second question, and that makes sure that everybody has a chance to ask their questions, and Dash Regan as well. So on that, if I can move on to Rona Mackay, and then I'll bring in Pauline McNeill. Thank you.
Thank you, convener. Good afternoon, panel. I just wanted, my first quick question would be to Professor Phoenix. In your opening statement, you said that sex work is always linked to violence and organised crime, etc., etc. The logical conclusion to that not be if it's decriminalised, that would improve the situation? If it's decriminalised, it would then not have those implications?
No, not necessarily. Okay, sorry, I was trying to figure out what you were meaning. So if we decriminalise the entire industry, including, would that reduce the amount of criminality connected to it? No. What it would do is introduce a two-tier system, because there will always be men who will be violent. There will always be people who will exploit women. A lot of the problem of prostitution actually has to do with male violence, has to do with gendered stereotypes, has to do with women's chances and life chances, has to do with histories of violence and abuse. So there will always be a system in which men will exploit women. And so the idea that if we simply get rid of all of the laws, that the market will then sort out the problems is naive, to say the very least. So the idea that if we decriminalize, then actually what regulates this thing called prostitution is the market. But the invisible hand of the market has never been the sort of thing that actually helps women, much less provides safety for them, if that makes any sense.
I mean, conversely, you could say it'd be easier to police if it was decriminalised. If there were, and there are violent men, I totally agree with you, there always will be. But if it was decriminalised, I mean, it's just a different viewpoint. I think I agree with my colleague, the overriding thing for all of us here, regardless of what side of the issue, is women's safety. I don't think anybody would disagree with that, but thank you for that. Can I come to Ruth, please? Again, going on the aspect of women's safety, we did hear an evidence about just general things that will make sex workers less safe under the model, one of which was an app which they currently use to sort of, flag up dangerous customers, clients, whatever you want to call them, and that's quite concerning. The other thing I wanted to mention was the point that you make about migrant women, and I'm struggling to see how they would be safer if the buyer was criminalised. And we did hear again previous evidence about migrant woman who was charged with brothel keeping because she was trying to keep herself safe with colleagues. She was arrested by police who appeared, anecdotally we're told, with a battering ram. She was arrested and they made stigmatising comments about her. So, I hear what you're saying, but there is also evidence that we've heard that said that that's not the case.
Sure.
And I wanted to just ask you, probably the panel, what their thoughts are on the fact that brothel keeping's not in the bill.
So there's been a suggestion that the brothel keeping legislation, which remains on the statute books in Ireland, that has been used against individual women in prostitution. And you mentioned one case there, but that is one case that has occurred, a very problematic case indeed, where the policing really fell down in terms of its standards. But that is one case in all the years that we've had this legislation, since 2017. If you look at the data I've provided, you can actually see that overall recorded crime for brothel keeping has been going down. If you dig into those cases that, as they are now happening, the cases that are being proceeded against, you will find that what the police are targeting is not individual women operating together for safety. It is crime gangs. It is gangs who are organising a network of brothels. So all of the cases we now see reported on, we're talking about individuals, not always men and women, organising a network of brothels, which they're moving groups of vulnerable women around from location to location. So just to correct that, the brothel keeping legislation is not being used in a negative way against individual women. There's this idea of working together for safety, but so many of the attacks that we see are happening in those circumstances where there's 2 or 3 women in a premises together, but what can they do when 9 men armed with knives come in? So I think there's a little bit of a false hope in that working for safety idea. I would also add that, there was some concern that an app where women can make reports would be somehow legislated against or be seen to be facilitating prostitution. We have an app like that in Ireland, and that hasn't happened. That app continues to run, and it hasn't been the target of any kind of policing. I just want to pick up on the wider issue of decriminalisation in terms of decriminalising those who organise prostitution. So you were asking the question there, well, if we decriminalise everything, doesn't it make it safer? But who continues with the organisation of prostitution after decriminalisation? It's not your local greengrocer or florist that decides to become a brothel owner. It's the organised criminal who was previously organising prostitution in your jurisdiction that now is given a carte blanche to grow that business even further because suddenly his illegal activities have become legal. So that's what happens in decriminalisation or legalisation, as we've seen in other countries.
And you have evidence of that?
Yeah, absolutely, because it's not new people don't enter the market and say, I was a florist yesterday, but now I'm going to become a brothel owner. That is just not what's happening. It's those who are profiting and benefiting in an illegal regime who their activities suddenly become legalised in this legalised or decriminalised regime.
Yeah. Okay.
If I can speak to the Australian experience around decriminalisation. It is not regulated by a market. It is actually still quite a heavily regulated industry, and it's regulated through council planning laws, development laws, zoning applications, and so on. So there is very rigorous things around how sex work is regulated in New South Wales. I'm very happy to provide a lot of research to show that. The evidence shows that it's really not organised crime. Actually bringing in decriminalisation has stopped that link with organised crime and with criminality, and brothels are regulated like all other businesses in New South Wales and must face those legal obligations that all other businesses do have as well.
Yeah, just one final, it's just a very quick comment, just going back to Ruth's point about the difficulties in prosecutions and possibly bringing in an on-the-spot fine. My instinct would be that men who pay for sex would pay a fine. I don't think that would be any great deterrent, but that's just my view.
Yeah, and there are some who are very entrenched in their behaviour, but at least I still think there's a determined element to that, because there's still paperwork involved in that potentially. And one of the things that men don't want to happen is their employer or their family to find out. And I think there's still the opportunity for that. So there's that deterrent effect there, I believe.
Okay, thank you. Thanks, Kabira.
I will bring in Jo Phoenix. I think she wants to respond just briefly, if you will, Jo.
Exceedingly briefly, yes. Some evidence about the nature of organised crime and its connection with prostitution. The International Labour Organization estimated in, I think it was 2023, that forced labour generates something like £236 billion globally in illegal profits. And somewhere around 73% of that £236 billion of illegal profits comes from sexual exploitation. So the idea that we can have a nice little cottage industry of prostitution where sex workers are in control of what they do, that doesn't have a connection with organised crime is, as I would suggest, extremely naive. That's all I wanted to say.
Okay, thanks very much. There is still a couple of members still to come in. I am going to ask if folk can bear with us, and we'll just run this session for another 10 minutes or so, just so that we can get through as much as possible. And just for committee members, proposing that we defer our final agenda item to a future session, if that's okay. Okay, so on that, I'll bring in Pauline McNeill and then Fulton McGregor.
Thank you very much. Good afternoon, everyone. I wanted to start from the point of view of the global exploitation of women and girls, sexual violence against women and girls, mainly by men. Well, I think we probably all agree on that. I'd like to think so. I'm not probing here for or against the criminalisation or not. I think that's been well covered, so just to say that. But what I'm interested in, particularly from Dr. Sandy and Dr. Valayarvi, is if we go down the path of removing stigma, and I know there's various levels of stigma attached to this, which you've articulated very well, and I agree with. But the normalisation of the sale of sex is the thing that concerns me most, and this is what I want to ask about. So Nina, maybe start with you. Would you not have some concerns that going down that path, can we really stop men sexually exploiting women by normalising the sale of sex?
I'm not completely sure if I understand the question correctly, because like sale of sex is not the same as sexual exploitation. And I think it's really important to make this difference legally and also kind of in a common sense. Because, like, for example, if we think that every time somebody sells sex, it's a rape or sexual exploitation, how can that person demand justice when they actually get violated? So
do you mean that, sorry to interrupt, so that, do you mean that, so I mean, I've listened to some sex workers who talk about their experiences of being exploited, sexually exploited by men, asking them to do things they didn't want to do, going beyond what the I suppose the initial agreement was, and it's surely that happens though.
Of course not. Yeah. That's what I'm concerned. That's what I'm concerned, and what I see is that this criminalising the sex buyer increases the vulnerability of women who sell sex to that exploitation.
Well, that's not what I'm talking about. Right. okay, maybe we don't agree on this, but the global exploitation of women and girls is primarily done by men. Organised gangs are mainly male, and the buyers are mainly male. So there's lots of evidence that men are exploiting women in these situations, even though the women are entering into it for the sale of sex. And that's what I've heard. But surely you must agree.
Yes,
that
and
happens.
I think maybe I'm getting the gist of your.
Men can't be trusted.
Yeah,
It's what I'm really saying.
No,
Can they
it's
be
just
trusted?
like I think you know, trafficking and exploitation of women in the sex trade is, you know, it's a really big issue, and I think, you know, when we think about the law, for example, it can serve different purposes. First of all, it would be kind of a question of resourcing. You know, where do we put the police resources? So, in my opinion, and looking at the research, or when I did the research, like, it didn't seem the most wise way of using police resources to police the clients. So if we think about in a context where the police could like direct more resources on actually detecting and investigating, for example, trafficking and sexual exploitation or children's sexual abuse, I think that would be like the wiser use of resources. Then again, there's like this kind of symbolic message point that proponents of this law often argue for. But what we, for example, see in Sweden is that the stigma towards buying sex has increased, but so has the stigma towards selling of sex. And people in general see kind of engaging in commercial sex as something that is harmful for the person. And this has led to marginalization of women who sell sex. They experience stigma in health services, with social workers. Like if they expose that they sell sex, they might get in trouble with their social worker and their child welfare offices, and so on. So in a way, like I understand this bigger concern of male sexual violence, which we know is rife. You know, we see the evidence all the time. Yeah. But I don't think this law, like having this symbolic law that necessarily doesn't have the effect of reducing violence against women. Like what we see that it does on the ground, it actually increases violence towards the people who are already vulnerable and marginalized. So this is kind of like what I struggle with, like with this kind of symbolic messaging with this law. So, yeah. I'm sorry, it was a bit convoluted answer. Yeah.
If I can, as well. The experience of decriminalisation in New South Wales hasn't really led to a normalisation, at all. And I do think we need to make a distinction here between sex work and sexual exploitation, as Nina's been saying. But one of the things that has happened here is, you know, understanding sex workers as work. It gives the boundaries as a worker and as a labourer. And as a person that's providing a service, and that's one of the ways in which a lot of workers have been able to address some of those issues around exploitation and challenge clients and everything as well. But the thing here, and I think what's at the heart of what you're asking maybe, is the financial need, you know, and the need to address the financial need. It's not really,
no, I don't think you've understood me. I hear loud and clear what you're saying about the pros and cons of legislating. I understand that, and that's the balance. That's what you've got to decide whether you think it protects women or not. But my concern is about the wider harm. If we agree that men tend to exploit women, if we agree that they're the main problem, whatever you do, even if it's meant to be you protect women to sell their bodies, and you reduce the stigma and all of that, can we really stop men exploiting women? That's really at the heart of what I'm saying. And can we really stop the wider harm to other women that are not in the sex trade by saying that it's a perfectly acceptable thing in society? I mean, I think that has to be... I think those who are against the bill need to answer that question. For me, anyway.
For me, it's a pragmatic response. Right? There is the financial need. If you are not going to do anything to be addressing that financial need, which has been discussed by everyone, here at this table and your former panellists as well, then how can we make it safe? right? And that's what faced the New South Wales government in the decision that they were making around decriminalisation. Okay, how can we improve safety for people working in the sex industry and make that paramount? And how can we prioritise that? And that was the decision-making process behind moving for decriminalisation rather than further criminalisation.
Women who are not involved in the sex trade, who are exploited by men in the world, I mean, do you think that the argument that you're putting up harms them in any way? I mean, to say that you would want to protect the sale of sex in any country, which is what I think what you're arguing, for all the right reasons, I understand that, but does that not have some harm to other women because of the very nature of men's attitudes to women? Or do you not think it does harm them? I mean, that's fine, but I'd just like to know.
I don't think it harms other women.
I don't.
Because if you are thinking of sex work as work, and within that framework, you are starting to change those gender ideologies, which are what you're talking about.
Yeah.
So it's a way to transform those gender relations as well. So fundamentally, I think looking at it as work is one way in which you can address that.
Could I ask Professor Joe Phoenix and Ruth Breslin too? Do you think there's a wider harm done if we... I'm not taking a view on the criminalisation or not criminalisation. I think you know what I'm asking, really. It's just the fundamentals here. How can any law really protect what is a global issue?
Yeah, I mean, I think that you've basically asked the big money question. Can I just talk specifically here about whether making prostitution legalised is going to, or not legalised, but decriminalising it, whether or not it's going to create more or less harm broadly. The simple fact of the matter is this. We have a problem with male violence. We have a massive problem in the UK at the moment. We have a complete crisis of policing of male violence in the UK at the moment. Any move to reinforce women as commodity is always going to be a problem. Does prostitution have a knock-on effect to other women? Yes, absolutely, 100%. You know, we're not talking about a small cottage industry. If I can just kind of like draw the committee's attention to fangirls, for instance, you know, it comes as no surprise that we're looking at a global industry that has now gone viral onto the internet, has all sorts of different manifestations now. It's not surprising that prostitution from the street has moved online and elsewhere, and that connects to the global scale of this issue. And to me, the idea that decriminalizing prostitution can somehow keep safe just a particular group of women from the broader problem of male violence, just like I say, I've said it before, I'll say it again, seems naive in the extreme.
Thank you. And lastly, Ruth.
There was a very helpful piece of research a number of years ago from the University of Edinburgh that interviewed men who'd been sexually violent towards women. And one of the key takeaways from the research is that those men saw those women that they had aggressed against as slightly less human than them. They didn't see that they had quite the same human value as those men. And I think nowhere in the world are women more dehumanised than in the global sex trade, with prostitution being the sharp end of that. I don't think the inside of a woman's body is a workplace. I don't think the inside of a woman's body is some kind of service provider. I think that the message from the sex trade seeps out into our wider culture through prostitution and through pornography. It seeps out into our wider culture, and it is telling young girls that their body is their primary currency, that how they look and how sexually attractive they are to the opposite sex is their primary currency. And Professor Phoenix mentioned it, the likes of OnlyFans, you know, the way the trade has been glamorised, particularly in the online world. I very much feel that the bar to entry is being lowered, because young women are being told this is a quick and glamorous way to make good money. It's empowering, it's sexy, etc. And yet when you talk to women who've been in prostitution, they'll say it's the least empowering thing that ever happened to them, and it wasn't about them expressing their sexuality, it was about sex buyers acting out their sexuality on their bodies.
I'll leave it there.
Thank you.
Thank you very much.
Gregor, and then I'll bring in Jamie Hepburn again. Fulton.
Thank you, Convener, and good morning, good afternoon, sorry, to the panel. So again, just like the previous week, we've heard two strong arguments for and against the bill. What I'd want to say is opponents of the bill generally seem to imply that its implementation will put women at more risk. That seems to be the general kind of feeling from the last two panels from those opposed to the bill. I have to say at this point, it's not a final position, I'm not overly convinced with that argument. I find myself inclined to identify with what Ruth Breslin said, that prostitution is inherently dangerous and violent, and that's regardless of any legislation. So what I wanted to ask was from the other side of the question. You might have a view of whether this bill should have been brought forward or not, but it has been by the member in charge, and it's here in front of us. And what I wanted to ask was, what are the implications if the Parliament does not pass it? What, if we do that, what does that say to vulnerable women and girls, to those who are currently sex workers, and to those who purchase sex? What message also does it send to our young men and boys in Scotland? And this is something that I've got real concerns about, because we've now actually got this bill in front of us, and it is here. And I wanted to ask, just going with what the convener asked earlier, I'll pick one person on each side of the debate. But what I wanted to ask is what do you think the implications are of starting a conversation on this issue here in our national parliament and then not acting? So, Ruth, because I mentioned you, I can ask you or somebody that's for the bill.
I think if we accept that argument that we've been making about an intrinsically violent trade, and I don't know exactly the profile of those in prostitution in Scotland, but if it's anything like the profile that we have in Ireland, and I showed that bell curve, if you don't act, and if you continue with the current approach, or even some of the decriminalisation approaches here, the trade grows. So right now in the world, we have a lot of push factors for women into the sex trade for a whole host of reasons, you know, that are going on in terms of migration, in terms of international crises, in terms of cost of living crises, etc., etc. So there's really tough push factors pushing vulnerable women into this trade. But if you leave things as they are and don't decide to tackle the buyer who is creating the demand for this trade in the first place, there is a risk of the trade growing. So in that bell curve, I suppose there's an issue of if you leave things as they are or don't address the buyer, there is the opportunity for everyone inside that curve to grow. So that includes the people who choose and describe this as work, but it includes the trafficked women as well, the numbers of trafficked women, and it includes that vulnerable majority that I described in the middle. So I think coming back to scale is really, really important. So New Zealand has been mentioned here a number of times as an positive example of decriminalisation. But if you look at New Zealand, it has a trade, and Ireland and New Zealand happen to have almost exactly the same population size, and they have a trade between 6 and 9 times larger than ours. So if you want to, do the kind of laissez-faire or do take this decriminalisation approach, you really risk growth in your trade, and that does mean more trafficking, more violence, more trauma, and I think that's something Scotland doesn't want.
Dr Dundee, can I come to you from a perspective of somebody that's not opposed to the bill? That wouldn't be right, but I've got some concerns with as it's currently drafted.
Yep. If I can, just first in New South Wales, where sex work is decriminalised, the instances of trafficking and modern slavery practices are very rare. I'm very happy to share the data that we do have on that, just to comment on that. But I think for the situation that you're facing and the question that you've asked, I think that the laws in Scotland do need to change. Right? So I don't think it should stay the way that it is. But my advice would be to talk with sex workers and to take the time to consult with them to find out what it is that Scottish sex workers think might be best for them and how their work might be best regulated. That was what the Victorian government did in bringing in decriminalisation in Australia. They spent a very long time consulting with sex workers, with NGOs, service providers, with the police over a very long period of time. And through that consultation and consultative process, involving all stakeholders, key stakeholders, they came up with the model of decriminalisation that they've just put through with the legislation in 2022. So my advice would be to actually talk with sex workers and find out what it is that they think would be best for how their work can be regulated.
Thank you very much. Thanks, Camilla.
Jamie Hepburn and then Ash Regan.
Thank you. Thank you, Camilla. I did say I was going to return to policing, but I'm not going to, I'm afraid, just because of time. I think you've said enough for us maybe to be able to pick up with Police Scotland directly. I do have a question, though, around demand reduction. Part of the notion behind this bill is that it will drive down demand. Ruth, I think I did hear you say that has been the experience in Ireland. Correct me if I'm wrong. Nina, you have presented information that says, there actually seemed to, maybe you can clarify this, there's seemingly a contradiction in my reading of what you've said here. In Sweden before, against after the law, there was a decrease from 13% to 8% of men reporting having bought sex, but then go on to say in Sweden 10 to 15% of men have bought sex. If you could explain that difference, that would be helpful. But you do then say there's no significant difference between countries with full sex buyer criminalisation, Sweden and Norway, compared to other Nordic countries. Could you speak to that a wee bit more? And then, Ruth, if you want to come in terms of the Irish experience, that would be helpful.
Yeah, so this was in reference to separate studies. So this is like the decrease from 13 to 8% of men report having bought sex. So this was like a survey that was done before and a little bit after the Sex Purchase Act. And the Sex Purchase Act was implemented in 1999. Then there has been other studies which show kind of the extent of people who have bought sex in the countries. And there we have a little bit different numbers. So that's just... we have in Sweden, we have 10 to 15% of men have bought sex to another survey. In Finland, it's 11 to 13, Norway 13, Denmark 13. And of course, these are like approximate, so it could be between, like, let's say 8 and 15 in Sweden, or 8 and 17, like, you know, depends on the amount of number, on the amount of people that has been that has responded to the survey. But the point was just to say that, like, you know, that we don't see kind of a massive difference in the percentage of men buying sex in the Nordic region, where we have very similar, for example, a state model, welfare state model, also levels of gender equality, which I think is very important. Also, like, you know, the engagement of women in commercial sex, you know, what kind of supports there are at place and so on. So yeah.
So your conclusion you draw, then I'm not going to put words in your mouth, you can tell me if I'm wrong, is that actually a change to the law in terms of criminalising the purchase of sex doesn't alter demand? Like, I think there, you know, you know, it's a study, so, you know, there was from 13 to 8% of men who reported buying sex. Of course, like, after it's been criminalised, might not, like, state in the same way. But I'm sure, like, you know, if you criminalise something, you know, law-obedient people, you know, some of them won't do it. So I'm not saying that it wouldn't have any effect, of course, you know, like laws have effects. Okay. Yeah. But in terms of the comparison between jurisdictions, I suppose, is the point I was making.
The point is just that, like, the law doesn't have a massive change. It doesn't show massively in the different regions, or even different countries in the region, which have similar social model in general. And I think, in general, when we think about, like, we have thought a lot about misogyny and violence against women and women's sexual exploitation. And I think these are very serious issues, but I don't think they can be solved by regulating prostitution or prostitution laws. I think these are issues that need different approaches. Okay. That's kind of bigger point I would like to make in this, because I do share the concern. Yeah.
Okay, that's useful. Ruth, what's the Irish experience?
My understanding, just in the Swedish context, is that Sweden's own review did observe a reduction in demand. So what the Irish review of the legislation says is that overall the legislation is making progress towards its various objectives that I've talked about today, that it has not been successful yet in really having an impact on demand, and that speaks to some of the implementation issues that I referred to. So instead of throwing the baby out with the bathwater, what the Department of Justice decided to do is to go back and look and say, right, how do we strengthen the provisions around that? So this is really around, I think, good resourcing for the police to do this work effectively. And it is also, I think, this is something I'd probably recommend for Scotland, like a proper awareness raising campaign for the public as a whole in this area, because we did not, unfortunately, have that in Ireland. And I think that that's something that was needed to get the message out even wider, that, you know, we've decided that this is now an offence and everybody needs to be informed of that. So I think we have hope for the future that we will actually make inroads in reducing that demand, because, again, it's reducing the demand to shrink the size of the trade so that less vulnerable women and girls end up in it.
I mean, maybe too early to conclude, but is maybe the bigger challenge the societal and attitudinal and cultural change would reduce demand more than the law per se?
And yet we have seen that happen in terms of, in Ireland, the law came first and policy followed, and there was a bit of a national conversation about these issues at the time. So policy followed because we developed a new strategy on gender-based violence just a few years ago, and for the first time ever, prostitution and sex trafficking were placed within that in the framework of violence against women and girls.
Okay, that's helpful. One final question, if I may, convener, and it relates to the area in the bill around support and assistance for women, primarily women, seeking to exit prostitution. I think I'm right in saying all three of your submissions, though, highlight the need for support for those, whether or not they intend to leave prostitution. And maybe you could speak to that as well. You know, it doesn't necessarily have to be predicated on a desire to leave.
Yeah, I'll speak to that to just say, there was a suggestion in the previous evidence session that in Ireland it's only women who want to leave who get support, and that just isn't the case. So I talked about that idea of services meeting women wherever they're at. So whatever the woman comes in through the door and says, you know, if she's describing herself as a sex worker, if she's describing herself as a victim of trafficking, if she wants to stay, if she wants to leave, no matter what that is, the service is non-judgmental and holistic, and just meeting a woman where she's at and assessing her needs and providing supports from there. And that's essential, I think.
Okay. I don't know if Dr. Sandy...
I concur. Absolutely concur with Ruth. Non-judgmental services, the services, there can be no condition to access those services that you must be leaving sex work or reducing your hours as well. And those services need to be provided to all workers within it, but within that non-judgmental framework, and they need to be properly resourced and funded as well.
Yeah, I concur. Again,
I don't know if Professor Phoenix has anything to add in that regard.
Nothing to add.
Okay. Thank you, Mira. Thank you all.
Thank you.
Into the panel. I think one of the difficulties really for the committee is that there have been a number of studies, there's been some research, there's been evidence that has been presented to the committee, whether that's in writing or whether that's through the oral evidence sessions. And they appear on face value to directly and completely contradict each other. So one side will say one thing and the other side will say the other. So I'm wondering if there's any guidance for the committee in terms of how to spot whether research or evidence meets a high basis, there's a criteria that could be applied. I mean, I would probably suggest that we need to be looking at high sample sizes, making sure it's statistically representative when we look at things that are being presented as evidence, that any research that's been undertaken shouldn't have any links at all to the sex industry. It mustn't be funded by them, it should be independent. So I'm wondering, I'm going to direct this particularly at Jo Phoenix because I think this is something that she has mentioned herself, but I was wondering if Ruth also wanted to come in on this. How should the committee work their way through this, and what's percentage, if that's possible to put a percentage on it, of the research would meet that very high bar of robustness?
Wow, okay, that's a really big question, and I'll try and take it into bite-sized chunks for you. When I said that, that there's a problem with research in this area, I don't think that it can be underestimated, the extent of that problem. Now, if I was to guide you all and say, how could you find the good research from the research that does suffer from some of the classic problems, what I would say is get skilled up on what those classic problems are. And so if I can give you just some simple things, I think that you can begin to see almost immediately the good from the less good. I don't want to say any research is bad, it's just good and less good. Good and less robust. You can see it literally from looking at the assumption that is made by the researcher. You can see that assumption by simply how they define their terms of reference. So the second that you see a research study that starts with, we're going to be looking at the effects of criminalising the purchase of sex. We believe that sex is work. Right? That means that the assumption is hard-baked in there. It's a sex workers' work approach. It means that everything about that study will be designed on the basis of that assumption. And that's where you end up with this confirmation bias. So if I can suggest that any research that starts from an a priori political position that, one, individuals ought to be free to sell sex if the conditions are right, will always be problematic, because that assumption will be based into to what is then done. But there's also a problem because the research on the other side also suffers from that same confirmation loop bias. So then what happens is, how can you sift through all of that? What I'd suggest to you isn't so much the high sample sizes, although that kind of helps, but rather look across the research and what it says. So we know that, you know, across all of the research, what it describes as, you know, particular problems within prostitution, particular problems around the policing of prostitution. And I just want to add one more thing, because I don't want to go on too long about, let's just have a little think about the confirmation loop and where else you can find that. The confirmation loop problem, if you like, also suffers or has another associated problem with it, and that's the false causality problem. And, you know, with the greatest of respect to my academic colleagues on the panel, when I hear things like, the evidence shows that there are more harms when we criminalize the purchase of sex, the first question I ask is how? What is that causal mechanism? And in fact, what the research never shows is what that causal mechanism is, beyond the myth that we have heard, that I've heard at any rate, since people started talking about criminalising curb crawlers, and that's women don't have a chance to assess potential purchasers, right? That's the only causal mechanism that I can see in the research. So what I would suggest is keep in mind how a priori political positions shape the very nature of the research. Don't buy into the bottom line numbers. Look at how that research was conducted. Look for the causal mechanisms that researchers are offering. And that's not complete, but I can certainly add a little note if the committee would find it helpful about some of the main problems, you know, picking out some of the main studies that perhaps the panel have looked at, and begin to pick out some of the logical academic errors that are in there.
Thank you. I can't speak for the committee as I'm not a member of the committee, but I'm sure they would be interested in taking up that suggestion. I'm wondering, Ruth, do you have anything to add?
Yes, just briefly, thank you. So in the run-up to the review of our legislation, Dr. Geoffrey Shannon, who's quite an eminent legal professional in Ireland, actually prepared a report for our government, making a number of recommendations in terms of how the review itself should be conducted. He noted the need to rely only on evidence that was reliable, verifiable and gathered in a rigorous way. And he said, and I'm quoting from his report here, the origin of the data must be verifiable and, if possible, can be triangulated from other sources. Researchers should have no past or present association with or financial relationship with sex trade organisers or those profiting, benefiting or promoting the sex trade. And I have to say, some of the evidence that ended up in our review or was put forward by our review does not essentially meet those conditions. And I would also say the same in relation to some of the data that was gathered about the law in Northern Ireland.
Thank you.
If I can.
I'm going to have to close it there. afraid. We are really well over time, so I am sorry. I am going to have to draw things to a close. Thank you all for joining us today. Thank you for coming online, Joe Phoenix. I think that's been a really invaluable session, lots for us to think about. So thank you again. And that concludes the public part of our meeting, and we now move into private session. Thank you. Thank you.